ತಗೊಳ್ಳಿ. Next week, Thursday.
Demolition and disposition of property without having passed any order, without having issued any notice by the BBMP. Therefore, may kindly request that the matter be taken up in Tuesday.
Why do you feel there's an imminent threat?
Floods. Yesterday they have come about 20 people BBMP floods. They come. They try to demolish the property. Great difficulty have
serve it on Mr. Power. ಡೇಟ್ ಕೊಟ್ಟಿಲ್ವಾ ಅದು ನೋಟಿಸ್ ಹೆಂಗದು ಡೇಟ್ ಕೊಡ್ತೀವಪ್ಪ ಎಲ್ಲದಕ್ಕೂ ಚೆಕ್ ಮಾಡಿ ಅದು ಡೇಟ್ ಮಂಡೇ ತು ಮಂಡೇ
Changing the demand by the.
ground rent demand notice is for ground rent at Monday, Tuesday.
Monday.
This is about legal construction, Mala. The construction is posing as a threat to my property, Mala. The matter was listed, we did not.
Nothing, no urgency to demolish it. It will come on the regular basis. Yes. It's
Not
already been agenda. You take it on that day.
Another matter.
Yes.
Lord, we always complied with the office objection.
It will come once you, that 5-day period, it will come. You don't need to move it. No urgency. It's already urgent, so don't. Yes, madam.
the cancellation of license here.
Cancellation.
One matter, Lord was pleased to dispose of the matter on 13/8/2023 with the direction to the chief officer of the municipality, town municipal council, Narsipura, to change the kata, considering the application within 30 days and report to the court, Your Lordship. Thereafter, the matter was listed before this honorable court, they did not file any report. Meantime, I filed a contempt petition before the court, because there is a violation of Your Lordship's order. Since there is a rider, took by Your Lordship in the order. But
That compliance would be for something else, not for your
that's
kata.
correct, Your Lordship. That's correct, Your Lordship. For compliance of report, not only to change the kata, only to.
Not only ಅಲ್ಲ ನಿಮ್ ಖಾತಾದಲ್ಲ ಬೇರೆ
Consider the application.
ಆಯ್ತು ಕೊಡಿ.
What said this, not remove the matter before the court.
So we'll
I understand.
dispose that by. Yes.
Monday.
And was applied for the information of road number, please put in your on.
When was it? It's an old matter. Date was given to when? When was the date given? 4th of December. 4th December ಬರ್ಲಿಲ್ವಾ?
My lord, the kata was standing in my name, my lord. The private respondent has filed the petition before the executive officer, my lord. Wherein I have filed the objections and documents, my lord. But without considering my objections, they stated that no objections are filed by the respondent and cancelled.
The neighboring property is being constructed, that date is the same. My property is situated in this. Immediately requesting we can be the national Monday.
Yes, good. Yes, serve it on Mr. Pawan Kumar.
One matter is directed in to post it on one. This full matter will not ready, they are not given. Just her time is already over.
ಯಾಕೆ ಬಂದಿಲ್ಲ? Monday to Monday.
We find already joint member, we taken up.
Tuesday.
Adjournments. Date number 11, serial number 3557. Date number 1, serial number 58 to 65. 62.
60?
I will inform other side. Approve it.
Request of counsel for the petitioner relist on February.
Date number 13, serial number 66 to 70. Date number 14, serial number 71 to 78.
Ramesh is not in station.
Request, have you informed?
Informed.
Request to counsel for the petition relist on 5th February.
Date number 15, serial number 79 to 84.
At the request of counsel for the petition relist on 5th February. 81.
For R5, objection 5 months.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
License.
ಮಂಡೇಗೆಲ್ಲ ಇಲ್ಲ, ಇವತ್ತು ಅಜ್ಜನ್ ಆದ್ರೆ ಆಲ್ರೆಡಿ ಇವತ್ತೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ನೋ ಅಜ್ಜನ್
ಅವರು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು.
ಇವತ್ತು ಇಲ್ಲ, ಫೆಬ್ರವರಿಗೆ ಹೋಗುತ್ತೆ. 81 at the council for respond number 564 and is granted 3 weeks time to submit no objection. Simply filed on or before 19th January, released on 24th January.
Date of birth 16, serial number 80 by 20.
No objection. Objection, no.
The petition council is not valid.
On consent, the date was fixed.
But she is not in the
With an objection, we won't adjourn. You prevail upon, you negotiate your adjournment. Yes.
Order serial number 1. Deputation trustee, collected matter.
One Prashant. Yes. Report file ಆಗಿದೆಯಾ? Inspection ಆಗಿದೆಯಾ? No inspection.
My lord, inspection was done, report was filed, my lord. Then my lord has wanted some clarification, my lord. That
Apparently no details were there. Yes. So after that,
Submission, Lord. Lord, on the last occasion, I had said that the ADLR must be taken into account, the ADLR's report. Somehow it's missing from the order, not just only incorporate that part.
ADLR has given a report on what?
So ADLR has to give a report in regard to the extent of land. On the last occasion, I had made that submission, Lord had agreed with you. And somehow.
Not come. ಇನ್ನ inspection ಆಗಿಲ್ಲ ಅಲ್ಲ? That council for respond number 1 submit that inspection is yet to take place. He seeks for a fresh date to be fixed for the inspection to be carried out. That council for respond number 2 submits that the extent of land. The extent of land would also be required to be determined, for which purpose ADLR would have to be issued necessary directions to carry out a survey of the land. What do you say, Mr.?
here, my lord, question of deviation, my lord. Question of ADLR constitution may not have.
If there's a land issue, then if it's within that, then the setback violation would come within the land.
That was, my lord, measured by engineer and he reported that there is, my lord, a deviation.
If the land is more, then the setback will get affected. If the land is less, it will get affected more.
The very fact that he's objecting to that, my Lord.
No, I have no.
Shows that.
Now they have started, my lord,
Objection.
my lord, one moment.
Objection and no objection. No objection, we'll record that. Objection, we'll deal with it.
ADLR could be assisted, my lord, I have no.
Counsel for the petitioner also concurs with the same. The jurisdictional ADLR is directed to carry out measurement of the land at the same time as respond number 1 is carrying out the inspection as directed on 18/11/2023. The date of the inspection and survey is rescheduled to ಯಾವತ್ತು ಮದುವೆ ಆಗಿದ್ದು, ಯಾವಾಗ ಬರ್ತಾರೆ? When will he come back to work? ಅವರು ಇರ್ಬೇಕಾ ಅಲ್ಲಿ ಏನು? ಯಾಕಾಗಿಲ್ಲ ಸರ್ವೆ? ನೀವು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ ಅಂತ. ನೀವು ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಲಿಲ್ವಾ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1? ಸರ್ವೆ ಏನಕ್ಕಾಗ್ಲಿಲ್ಲ? ಮಾಡಿದೀನಿ ಅಂತೀರಾ, ಮಾಡಿಲ್ಲ ಅಂತೀರಾ, ಏನ್ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ರಪ್ಪ. The survey to the inspection survey to be carried out commencing from 10:30 AM on 4th January 2024. Report to be submitted by 23rd January 2024 after serving a copy thereof on the counsel for the petitioner and respond number 2. Objections, if any, to the said report to be filed on or before 2nd February, released on 8th February. State is not a party. The party in the second matter. One point one copy has not been furnished.
That's all.
1.1, you have the copy. In the first matter, you are not a party. Yes, Mr. Shastri, though the state is not a party, give them a copy.
My grievance was against town panchayat only, my lord. I shall.
That ADLR has been asked.
I shall.
A copy of this also. That in WP 52862 of 2015, counsel for the petitioner is directed to furnish a petition on with all annexures on the learned SCD.
Holding maximum petitioner died, therefore I was unable to take steps to R4. Now I filed the IA. If IA 1 of 23 is allowed, I will comply, I will take steps.
Adadmela, during the pendency of the above matter, the sole petitioner expired on
1/6/2021.
1/6/2021, hence IA 1 to 3 of 2023 have been filed. Accepting the reasons stated in support of IA 1 of 23, delay of
43 days.
743 days is condoned. Accepting reasons stated in support of IA 2 of 23, the abatement in respect to petitioner is set aside. By allowing IA 3 of 23, the person named therein are brought on record as P1A2, as P1A. Counsel for the petitioner to carry out necessary amendment and file amended cost act. He seeks for and is, counsel for the petitioner seeks for and is granted 3 weeks' time to file necessary application to bring the legal representative respond number 4 on record. Relist on 2nd February. ಏನಮ್ಮ ಆಯ್ತು 313, 300 square feet
With the alternative side, any other area.
of the same time.
I perform.
ಬರೋದು ಬಿಟ್ಬಿಟ್ಟು ನೀವೆಲ್ಲೋ ಹೋದ್ರೆ you appear for these organizations, you know what happens.
Townships have tried to withdraw the entire controversy. If they want to be in control.
ಕೈಗೆ ಬಂದಿದ್ದು ಬಿಟ್ರೆ ಮುಗೀತು.
Was not this, they were there. You were voting, you were, What is the?
We can empathize with your client and sympathize also. If you let go of this, you are in for another 5 to 7 years of litigation. In murder, if they is not willing. The petitioner is without his court. But you don't want that, Alva. So, ಅದು ಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ ಬೇರೆ ಎಲ್ಲರೂ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬೇಕು. Directed, but when will you get it? Petitioner is before this court seeking for the following reliefs. The CITB Mysore, erstwhile CITB Mysore had formed a layout for the Satgarli extension in 1987-88. The petitioner, being a owner of land to an extent of 4 acres in survey number 19, was allotted a site number 526 in the said extension on 28/5/1993 under the land user scheme. Petitioner Vella. Okay, one Channachari was allotted. He sold the said site to Janab Mohammed Tayyib on 26/10/1975, who in turn sold it to one Mr. Srinivas. There being certain issues with the said site, the said Srinivas made an application for allotment of the ordinate site, in pursuance of which site number 315 of Satgarli extension was allotted to him on 21/1/2003. He in turn had sold the said site to the petitioner under a registered sale deed dated 36/2006, which was in the possession and occupation of the petitioner having put up a construction thereon. 7th respondent On account of alleged interference by seventh respondent, yeah, seventh respondent. Sixth respondent, is seventh. Sixth respondent. The petitioner was constrained to file a suit in OS number 56 of 2015 for permanent injunction. The sixth respondent contended that site number 315 did not exist. The owners of 1 acre 12 guntas in survey number 37/1, having surrendered 2/3 of the land to the first respondent Muda, were permitted to retain 17 guntas therein, wherein they had formed certain sites which came to be sold by them. One of them being to Srimati Yamini under a sale deed dated 31/12/2012, who in turn sold it to the wife of sixth respondent. The petitioner thereafter had followed up the matter with the Muda, seeking for an explanation as to the existence or otherwise of site number 315, when he was informed that the site number 315 had been formed. Hence, the petitioner is before this court.
Formed that there was a resolution of Muda by which 17 guntas was.
However, later on, he was informed that 17 guntas of land had been released in favor of the landowners. So, site number 315 fell in that 17 guntas. And as such, the allotment of the site in his favor was brought in question by way of a resolution dated 28/5/2005. Agreed by the same, the petitioner is before this court challenging said resolution. On notice being ordered, a inspection and objections being filed, a inspection of the property was directed to be made by the Muda, which was so made, and a report submitted that the petitioner has put up construction of a small house in the said property, and the petitioner is in possession of the said site. In pursuance thereof, a memo came to be filed.
I purchased by sixth respondent. I claimed by the petitioner or one and the same.
We'll come to that. A memo was filed by respondent number 1 and 2, enclosing a sketch of the layout with a superimposition of the 17 guntas retained by the landowners. On verification of the same, it is found that site number 315, which had been allotted to the petitioner's vendor, was also permitted to be retained by the landowners in survey number 37/1, 37/5.
It became 37/5.
37/1, who in turn had formed 13 sites. The site number 315, which had been allotted to the vendor of the petitioner and subsequently purchased by the petitioner, was numbered 1 by the said vendors, and it is the said site number 1 that respondent number 6's wife has purchased. The submission of the learned counsel for the petitioner is that once there is allotment made in favor of the petitioner, the question of the said property, petitioner's vendor, the question of the said property being allowed to be retained by a landlord would not arise, and the interest of the petitioner cannot be, the prior interest of the petitioner cannot be supervened by way of such retention, and the petitioner who has constructed a house thereon cannot be deprived of the site and the house in site number 315. Learned counsel for respondent number 6 would also submit that there is no fault on part of respondent number 6, inasmuch as it is the Muda which had permitted the retention of 17 guntas with the landowners, who had in turn formed 17 sites, and one of the sites has been purchased by the wife of the 6th respondent. As such, the interest of the 6th respondent also would have to be protected. And the lapses on part of the officers of the Muda cannot be permitted to adversely affect respondent number 6 and his wife. In that view of the matter, the Muda was directed to verify if there was any other site which was available in the very same layout to be allotted to respondent number 6. The Shri T.P. Vivekananda, Learned Counsel for the petitioner, upon instructions, has filed a memo on 1/12/2023 stating that site number 313 in the very same layout was available. However, the said site measures 12 into 18 meters, which is less by around 300 square feet, while compared to site number 315. Learned Counsel for respondent number 6 had sought for some time to verify, to obtain instructions from a client and make a submission as to whether respondent number 6 was acceptable to site number 313 in lieu of 315. Today, she submits that the respondent number 6 is not so agreeable, but seeks for a direction to the Muda to allot a similar sized site in any other layout formed subsequent to the Sapta in layout either Saptahalli layout. So and so.
Or any other layout.
Subsequent or any other. Prior ಹೋಗ
Same layout or any other.
Same layout or any subsequent. Same layout ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದಿರ.
ಆ ಸೈಟ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ವಿ. ಅವರು ಅಲ್ಲೇ ತಗೋತೀವಿ.
Litigation. The short question in the that arises in the above matter is, could the interest of the petitioner in the site allotted to its vendor be infringed upon by the Muda who had allotted the said site by allowing the landowners of survey number 37/1 to retain 17 guntas in their lands. Admittedly, the allotment of sites in site number 315 in favor of the vendor of the petitioner was made prior to the permission granted by Muda to the landowners to retain the said sites, said 17 guntas. It was but required of the officials of the Muda to verify at that particular point of time if the area which had been permitted to be retained by the landowners had been allotted to a third party or not. Without doing so, the officials of the Muda have permitted landowners to retain 17 guntas, which includes site number 315 allotted to the petitioner. In my considered opinion, no such retention could have been allowed to be permitted in respect of the site which had already been allotted to the vendor of the petitioner, and a right title and interest created in favor of the vendor of the petitioner was transferred it to the petitioner. Hence, the resolution which had been passed on account of the said retention, informing the petitioner that site number 315 would fall to, cannot be used by him, is required to be quashed.
The resolution is not taking the request of the petitioner. By that resolution, 17 guntas was released in favor of the landowner. No such
Really, Dadala. Mr. Bhairappa,
by 2005.
is that no resolution, page number?
Resolution is at page 87. Yes, ma'am. Resolution, the landowner was permitted to retain one third of the land.
Third bhaga. In that view of the matter, the resolution, the impugned resolution, 28/5/2005,
It not be quashed, my lord. It
cannot be quashed,
not be quashed. This is,
permitting retention of 1/3 of the land in 1/3 out of survey, 1/3 out of the extent of 1.12 acres in survey number 37.1 cannot be found fault with. But however, the said resolution cannot affect the allotment made to the vendor of the petitioner. Hence, I pass the following order. Writ petition is partly allowed. It is declared that the resolution dated 28/5/2005 at Annexure S shall not operate against the petitioner and or his property in site number 315. Petitioner shall be entitled to hold a said plot and enjoy the same as owner thereof in terms of the allotment made by the Muda, and if a sale deed has not been executed, Muda is executed. Insofar as respondent number 6 is concerned, since the respondent number 6 interests have suffered on account of the marking of the area of retention without verifying that it has been allotted in favor of the vendor of the petitioner, Muda is directed to allot a suitable alternate site of the same measurement in the same layout or any subsequent layout within a period of 90 days from the date of receipt of copy of this order. Respondent number. ಅದೊಂದು ಅಫಿಡವಿಟ್ ಹಾಕಕ್ಕೆ ಎಷ್ಟು ದಿನ ಆಗುತ್ತೆ? ಅದಕ್ಕೆ 3 ದಿನ ಅಡ್ಜನ್ ಆಗುತ್ತೆ. Counsel for the respondent once more seeks for short accommodation file the affidavit as directed on 2/11/23, released on 20th. If affidavit is not filed by that time, the respondent shall be personally present before us.
Direction for issues to principal secretary, RDPR, my lord. This is with regard to service of notice and what happened. So Secretary RDPR was directed to file the affidavit. In yesterday's directions, even this will come, this will be covered, my lord. We'll comply everything and file the complaint report.
ನೀವೇ ಮಾಡ್ಬೇಕಪ್ಪ ಇದೆಲ್ಲ
My lord, today in 1986 of 2022, my lord, sir.
should do it by yourself. Why should we do it?
We will do it.
Yes, what about this? No, in view of the oral submission made by learned AGA, the affidavit to be filed by order date 4/9/2023 is dispensed with. Yes. Objections ಹಾಕಿದಾರ ಸೌಮ್ಯಾಜಿ ಅವರು? Rohit Gowda. And appears for respondent number 4. 3 weeks time is granted to respondent number 4 to file a statement of objection. Objections, if any, by 31st January, released on 8th January, 8th February. Twenty
ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರು ಅರ್ಜೆನ್ಸಿ ಅಂತ ಲಿಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಇದಾರೆ. ಮೂವ್ ಮಾಡಿದ್ರು ನಮ್ಮ
ಹಳೆ ರಿಜಿಸ್ಟರ್ ಆಗಿ ಸಬ್ಮಿಷನ್
ಇದು ಗೊತ್ತಿಲ್ಲ. ಅಶೋಕ್. Application you will file.
ಅವ್ರು appear ಆಗ್ತಾರೆ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ಈಗ actually documents ಸ್ವಲ್ಪ. I'll inform you.
That counsel for the petition seeks for and is granted a week's time to file necessary application for substitute service. He is also directed to serve 2 sets of the petition along with annexures on the counsel for respond number 1, 2, and 3. We list on 5th January.
Is it number 8?
Exchange of side, my lords.
R2.
I appear for R2, my lords. We have not been provided with the wakalat and the information, my lords.
Respondent counsel never appeared, so we changed the.
They haven't received instructions from the housing board.
No, my lords, I have not got any instructions, my lord. We have provided them the copy of it and the entrustment also.
When did you provide it, madam?
A week ago, my lords.
The counsel for respond number 2 submit that though the copy of the petition has been furnished to the respond number 2, she is yet to receive the wakalatnama and or instructions in relation to the above matter. She seeks for and is granted 2 weeks' time to file a wakalatnama and objections, if any, to the matter. If no instruction are received by 12th January and no submissions are made by next date, the respond number 2 shall personally remain present before this court. Read list on 19th January. Taken for R4. That counsel for the petitioner seeks for and is granted 2 weeks' time to take out and summons on respond number 4, relist on 22nd January.
You have not yet issued the report of the government. That is directed to.
On filing of survey report by AGA. Right. Namag band. Petitioner ಆಯ್ತು. ಎಲ್ಲರಿಗೂ ಕೊಡ್ಬೇಕು ಯಾರ್ಯಾರು ಇದಾರೋ ಎಲ್ಲರೂ. They'll get affected. Survey report has been filed. The same is taken on record. What is the action taken report? What is Please, Oh, ಇದು ಅಜಕಾಲುವೆ ತಮಿಳುನಾಡು.
Petition action to fix the fencing on both the Karnataka. Who says that doing the survey records it has not mentioned exact measurements by law. Basic measures 10 meters, 10 meter agala 160 meter style is what which they
10 ಮೀಟರ್ ಅಗಲ ಅಂತ ಇಲ್ಲಿ ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಹೇಳಿದ್ದೀರಾ? ಇದು ಆಕ್ಚುಲಿ ಆನ್ ಸೈಟ್ ಆನ್ ಸ್ಪಾಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಇಲ್ವಾ?
ಇನ್ನು ಕಾಲಕ್ಕೆ ಲಾಂಬಿ ಮತ್ತು ಜನತೆ ಆಗಲ್ಲ ಇರುವುದಿಲ್ಲ.
ಇದೆಲ್ಲೂ ರೆಕಾರ್ಡ್ ಇಲ್ವಾ ಇದು? How can anything be enforced against it without somebody will say 1 meter, somebody will say 10 meters, somebody will say 20 meters. You should have some record for that. ಮಾಡೋದು. But somebody will, one of them will come and say, they'll dispute the extent now.
ನಮ್ದ ನಮ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ, Petition ಅಲ್ಲಿ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ನಮಗೆ ನೋಡಿ
ಇಷ್ಟಿಲ್ಲ ಬರೀ 2 ಮೀಟರ್ ಇದೆ, 8 ಮೀಟರ್ ನಮ್ ಲ್ಯಾಂಡ್ ಅಂತೀರಾ?
ಅಲ್ಲ ಇದು ಇಂಟ್ರಿ ಮಾಡು ಕೂಡ ಆಗಿದೆ ಸಾಲ್ಮ ಕೊಟ್ಟಿಂದ KLR ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ನಾಟ್ ಟು ರಿಮೂವ್ ದ ರೋಡ್ ಅಂತಾನೆ ಇಂಟ್ರಿ ಆಗಿದೆ. ಅದನ್ನು ಏನು ಇಲ್ಲಿಗೆ ಗಮನಕ್ಕೆ ತಂದಿಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಸಬ್ಮಿಟ್ ನೋಟಿಸ್ ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ರಿಮೂವ್ ಮಾಡಿ ಅಂತ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ವಿ. ಅದಕ್ಕೆ ನಾವು ಇಂಕ್ಲೂಡಿಂಗ್ ಹಾಕೊಂಡು ಬಂದಿದ್ವಿ.
KLR ಮ್ಯಾಟರ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ಆರ್ಡರ್ ಆಗಿದೆ R3 ಮೇಲೆ ನಿಮ್ಮ ಇಂಕ್ಲೂಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್.
If there's a different matters filed before different courts, how do, there's no system for you to know? ನಿಮ್ಗೆ ಇಲ್ಲಿ ಗೊತ್ತಿರಲ್ಲ, ಅವ್ರಿಗೆ ಇಲ್ಲಿರೋದು ಗೊತ್ತಿಲ್ಲ.
ತಹಸೀಲ್ದಾರ್ ಪಾರ್ಟಿ ಇದ್ದಾರೆ, ಅವರೇ ಇಶ್ಯೂ ಮಾಡ್ಬೋದು. ತಹಸೀಲ್ದಾರ್ ಪಾರ್ಟಿ ಇದ್ದಾರೆ, ತಹಸೀಲ್ದಾರ್ ಫೈಲ್ಡ್
Area comes. That clearing it every week. When it comes to agriculture land, then there will come into picture.
Domin Council is also party.
There are two issues which you have raised now. One is the width to length to illa. Another parallel matter is going on which you don't have knowledge, they won't have knowledge of this. How do we handle both of these?
This area comes purely under the transfer side. Okay, Baroda. Transportation money.
15 days back.
That area. Totally under disciplinary.
Narendra is saying that there's a stay in the other matter.
What they say is, my lord, regarding only the road. That road, my lord, is in page number 3, my lord.
Yes.
One that runs above the small tunnels which have been made there. That is the only area of dispute. But to remove the encroachment and debris, my lord, there is no easy matter operating. Now that can be, my lord, done good by them. That is the submission that was made on the other day. That encroachments will take care later, but the debris and the construction material could be removed out, so that the flow of the water could be ensured. On that submission, my lord, the matter was standard.
And AG is filed a survey report, the same is taken on record. In terms of the said report, she submits that the width of the Raj Kalwe is 10 meters at site. And there are no records which are available indicating what is the length and width of a Raj Kalwe, including in the revenue records. It is rather surprising that the width and the length of Raj Kalwe is not available. The same, if such details are not placed before this court or concerned authority, it will be difficult to enforce the same. In that view of the matter, respondent number 1 is directed to look into this serious issue and prepare a database of all the Rajakalways coming under his jurisdiction. Respondent number 1 and 2 are directed to look into the matter and prepare a database of all the Rajakalways falling within their jurisdiction, with all necessary details, including the length and width, which can be verified in a verifiable manner for the purpose of implementation and assessment. The counsel for respondent number 7 and 8 submit that he has filed another writ petition, WP number
R3 11-9 WP 11-982 of 23.
23 bracket WP KLR bracket close, where an order of
Remove that portion of the fencing which blocks access to the petitioner property from the public road for free.
the order copy.
R3 Malala, I am producing
R3.
my including application. Wait on 5th December 23.
Page
21 Malala, 20 and 21 Malala.
When a coordinate bench of this court I have directed Tahsildar and the project manager, Bengaluru Nirmiti Kendra, 3 and 4 ಅಂತಿದೆ. Tahsildar and project manager.
3 and 4.
Project manager, Bangalore Nirmiti Kendra, to remove the fencing which blocks the access to the petition property from the public road. We submit that in view of the said order, Tahsildar and the respondents, the state herein cannot seek to widen to carry out the removal of the debris and other works, including removal of a road, which provides an access to the to his property. So an order has been passed by a coordinate bench, the same would have to be obeyed by the concerned authorities. This however gives to another issue in as much as on the very same land or portion thereof, there are 2 writ petitions filed in 2 different jurisdictions of this court. Which is not to the knowledge of the third additional AGA until it was brought into until the impleading application was filed. Respondent number 1 and 2 would also be required to devise a methodology to instruct their respective counsels in the matter about the pendency of any other matter, pendency of any other case on the very same subject matter, so that there are no contradictory orders passed, and their lawyers are aware of the existence or pendency, pendency or disposal of a proceeding in respect of the very same subject matter. Necessary report in this regard to be filed by respondent number 1 and 2 within 8 weeks from today. The counsel for respondent number 5 had earlier indicated that the debris would be removed within a period of 15 days. Hence, relist on 8th January.
Mr. R1, Ministry of the have given so-called notice to me. But
And the order ತೋರಿಸಿ ಅಲ್ಲಿ. That's why we have observed that it will have to be obeyed by the concerned, and we have observed that.
remove the road, remove
Last time we have dealt with. Cooperation of the, who is not cooperating? Who is appearing? Or he is cooperating, alva? He is only doing it. Needless to say, the concerned authorities, including respondent number 5, would have to cooperate with respondent number 1 to 4 in complying with the direction of this court.
ಅವರು ಈಗ ಡ್ಯೂಟಿ ಮಾಡೋ ತೋರ್ತಿದ್ರು ಇವರಿಗೆಲ್ಲ
That's not passed in this matter, Mr. Rao. That's passed in the other matter.
ಅದರ್ ಮ್ಯಾಟರ್
So you cannot deal with that.
on the basis of implement passages almost earlier they have given so-called notice to me remove the road ಅಂತ ಮಾಡಿದೆ ಅದು ನನಗೆ ಈಗ ಅದು
ಹೇಳಿದೀವಿ, it has to be obeyed ಅಂತ ಹೇಳಿದೀವಲ್ಲ. We can't say more than that. If they still don't do, you'll have to file contempt in that matter. This the coordinate bench order, earlier order passed, cannot override that order. Yes.
On the previous page, we submitted that gradienti is constructed of a wall on the rear entry. What is the correct
what has been checked by the residents of issue the the person to remove that wall, that notice has been served is.
No notice is required. It's a road. Subsection 2 of section 229, you can do it immediately.
Summarily, we can edit. The even Malad.
If somebody has been blocked, Mr. Pujila.
Respondents Malad, there was a compound wall earlier. Now recently, the petitioners have kept it there and removed the compound wall.
They're entitled to.
Yes. And then Malad, the residents of the, because of the traffic, it is a very small road. They're measuring 8.5 meters. Because of that, residents complained to the BBMP to remove that gate. Because of that, Malad, we had issued annexed area notice to the petitioners, asking to file objection if they have objection for closure of the gate. Meanwhile, the residents again put up the compound wall.
It's a public road.
Now we are issued, Malad, will take action, Malad, we have to send a notice to them.
Road. But
It is notice to them.
you can close the public road. ಆಮೇಲೆ ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ನಮ್ ರೋಡ್ ಅಲ್ಲಿ ಟ್ರಾಫಿಕ್ ಬೇಡ ಅಂತ.
Was it, there was a compound wall earlier, after this apartment has been constructed. They are affected it. Then it was.
Respondent number 1 and 2 has filed a memo dated 15/12/23. Stating that notice has been issued. Third respondent and the compound wall which has been put up would be removed within on a public road, will be removed within a period of 7 days by taking necessary recourse to subsection 2 of section 229 of the BBMP Act 2020. Released on 3rd January. Interim order earlier granted to the extent till next date. Page number 5. Decide.
They are only 3 feet rolling. Therefore, in view by the equity, one of the so which was built 0.13 acres of land reserved for public road and drainage was ordered to utilize for widening of road. Public.
2023 order we handle.
It 2.
8/2/2023.
ಯಾವ್ದ್ರಲ್ಲಿ 8
3600.
Six double zero only 8-1. There is no 8-2 in both of them. This starts with 21-3, that starts with 28-7.
ಇದರ ಆರ್ಡರ್ ಇಲ್ಲಿ ತಮ್ಮ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್
ಮತ್ತೆ ಅನೇಕ್ಷರ್ ಅಂತ ಹೇಳ್ಬೇಕು.
referring to it to passed by the deputy commissioner.
So which, where is that?
in WP 15201 of 2023.
Page number,
Annexure P,
page number,
page 90.
yes.
Anything notes the subject. ಮಂಗಳೂರು ತಾಲೂಕು ಕುಳಾಯಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 77 ಸಾರ್ವಜನಿಕ ರಸ್ತೆಗೆ ಕಾದಿರಿಸುವ ಬಗ್ಗೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ಅವರ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಸಂಖ್ಯೆ 77 ದಿನಾಂಕ 8/3/2022. By virtue of this 8/2/2023 order, got to the deputy commissioner, document
322.
8/2/2023 is the annexure P, page 90.
8322, 8223.
ಅಲ್ಲ, ಇದು this particular order is dated 8/2/2023.
Yes.
By virtue of this order, he modifies the earlier order dated 8/3/2022. Herein, my lords, we are all parties to that proceedings. 8/3, my lords, may kindly turn to annexure G, page 61 now. Petitioners before my lords. Connected matter.
And you are not party to this at annexure P.
Annexure P, we are not a party. Without even issuing the notice to us, and even without sending the copy to us, at the instance of the private respondent, they have proceeded to pass this order. That is what is challenged in the connected request.
Dikshru Grama Sangh,
That is the private respondent.
your Manvi Dinanka 3920. Where is that Manvi of 3922? Where is that Manvi of 3922?
Manavi or Nami copy ಕೊಟ್ಟಿದ್ದು.
Yeah, madam. Have you enclosed it?
The amendment. They passed this 8/2/2023 order behind our back, yielding to the political pressure exerted by the respondent number 7. Respondent number 6.
Did you issue a notice? Jilladhikari, Abu Jilla. The deputy commissioner order. Did you issue a notice before annexure P was passed?
No notice, my lords, no opportunity for us.
On that preliminary ground only we'll have to question.
That is the basis for granting interim order by my lords.
You hear them and then pass orders. In 201 of 23. Petitioner is before this court seeking for the following reliefs.
201 of 2023. By placing reliance on this order, 8/2/2023.
And that order was passed.
That order came to pass.
The grievance of the petitioner is that the interim order dated, notice dated 31/20/23, notice dated 17/6/23, order annexure A and B have been passed on the basis of the earlier order dated 8/2/2023, annexure P to the petition, which order had been passed without notice to the petitioners, and said order modified the earlier order dated 8/3/2022 at annexure G. A parallel of the order dated 8/2/23 at annexure P does not disclose any notice having been served on the petitioners. No document to that effect has also been produced by the respondents. The order dated 8/2/23 and at annexure P and the order dated 8/3/2022 at annexure G relating to the very same subject matter. It was but required for respondent number 2 to have issued notice to the petitioners before considering the request of respondent number 6 dated 30/9/2022 and passing the order dated 8/2/2023. Number 5. In that view of the matter, I pass the following order. Writ petition is allowed. so and so are quashed, A and B are quashed. The order dated 8/2/2023 at Annexure P is also quashed. Other question matter are quashed. The are quashed ಅಷ್ಟೇ. Connected matter.
Six double zero of 2023 initially filed for mandamus. And they came up with the plea that they modified that out. Thereafter, I filed amendment application that is allowed.
Certiorari of 8/2. Petitioner is before this court seeking for the following reliefs. But the annexure numbers change. The grievance of the petitioner is that the order dated 8/2/23 at Annexure T has been passed without a notice or hearing being granted, without a notice, let alone hearing being granted to the petitioner. ಇದರಲ್ಲಿ ಅದು 8/22 order ಅಲ್ಲಿ annexures. The contention of the counsel for the petitioner is by order dated 8/3/2022-23 at Annexure T. The order dated 8/3/2022 at Annexure A has been modified as regards which the petitioners were parties, without affording an opportunity of hearing without issuing a notice to the petitioners. There being no document which has been placed on record indicating any service of notice before the impugned order at Annexure T was passed, I am of the considered opinion that the writ petition is required to be allowed. The certiorari is issued. The writ petition is allowed. The certiorari is issued. The order dated 8/2/23, bearing number so and so at Annexure T is hereby quashed. The matter is remitted to the Deputy Commissioner. The Deputy Commissioner is directed to issue notice. The petitioner shall, since the order is passed in the presence of the counsel for the petitioner shall file its objections to the complaint and or representation submitted by respondent number.
Responding number in this petition,
Respondent number 6 within a period of 15 days. In a period of 21 days, vacation is in a period of 4 weeks from the date of receipt of a copy of this order, be there any which way the said objection to be filed on or before the date of receipt. On or before 11 January 2024 by 3 p.m. and the petitioner, as also respondent number 6, shall appear before the Deputy Commissioner, who shall take up the matter for hearing and pass necessary orders in accordance with law within a period of 30 days thereafter.
license. Replacing reliance on this.
Wait for this resolution, otherwise ನಿಮ್ಮ construction ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಆಮೇಲೆ
ಆಗಿದೆ, ಈಗ demolish ಮಾಡಿ ಅಂತ ಇದೆ.
don't do any construction until this is sorted out.
Correspondence number 1 to 4, madam.
Yes.
Serial number 20.
Yes. Who is to file the
What has to be filed in 13.1 minus.
yes? Pay the report, madam. And we have said that report is not proper and directed you to file a fresh report. That is why we have directed respondent number 4 to be present. Pay the report. If there is no report, we'll have to send him somewhere else. He won't be going back home. go and find out. Monday. Respondent number 4 is present before this court. Adhe Kerala. Circulate it to all your officers so that there is no. Because anyway, DG Fire Services report work bandide. You've seen that now. A well and detailed details. That will help the lawyers to understand what has happened. Then you can explain to us also. ಅವ್ರು ಕೊಡೋ ರಿಪೋರ್ಟ್ ಅವ್ರಿಗೂ ಅರ್ಥ ಆಗಲ್ಲ, ನಿಮ್ಗೂ ಅರ್ಥ ಆಗಲ್ಲ, ನಮಗೂ ಅರ್ಥ ಆಗಲ್ಲ. Be understandable by lawyers. They may be technical people. You are not. So you will not understand, you won't be able to convey to us, we won't be able to understand, it become a problem. Respondent number 4 is present before this court. He seeks for 2 days time to file the inspection report in the with proper details. We list on 20th. On filing of affidavit record 2711. Where to file the affidavit? And summons. Yeah. On respond number
That's 11 sleep.
11. 11 serve ಆಗಿದೆ.
ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
Court notice serve ಆಗಿದೆ.
Please.
Served ಅಂತಿದೆ cause list ಅಲ್ಲಿ.
After the
11 is served ಅಂತಿದೆ cause list.
I think I do the word for that.
Cause list ಅಲ್ಲಿ 11 ಸುಧಾಕರ್ served ಅಂತಿದೆ. Counsel for the petitioner has filed an affidavit of service of hand summons on respond number 11. ಎಲ್ಲಿ ಅವ್ರ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಎಲ್ಲಿ? Acknowledgement had earlier been filed with a memo dated 27/11/23. And service on respondent number 11 is held sufficient. Yes. What about you, madam?
And I, objection is ready, I'll look in the next.
Ready? In the ready na?
I'll look in the next day.
It has given you 3 opportunities for them to present.
I file it right now.
Counsel for. Again, what is the relief that you are seeking?
Challenging the Kata.
The counsel for respond number 1 and 2 as also the on behalf of Shri Prakash MH. 2 weeks time is sought for to file the respective statement of objections if any by 12, released on 19th.
Right.
Right. One of 23 anything. And appears for the petitioner. If you list on 2nd February. In the meanwhile, objections to be filed by respond number 2 to 4. Petitioner's hold. Is Kamala Chan. Seventeen is petitioner's property. You ಏನ್ರಿ ಹಿಂಗ್ ಕಟ್ಟಿದೀರಾ?
All three properties are there. The petitioner, there is no setback, but it's second 2013.
So what? You construct the way you want and you don't want them to construct. Take action against it, even if it is old. This kind of a construction that you have done and you want to take the age factor into account.
License and the plan with
ಇವನು ಸರಿಯಾಗಿ ಕಟ್ಟಿದೀರಾ, ನಿಮ್ಮ ಮೇಲೂ ಆಕ್ಷನ್, ಅವ್ರ ಮೇಲೂ ಆಕ್ಷನ್.
outside or north side by the summer.
ಏನಾಗಿದೆ ಅಂದ್ರೆ they obtained the plan for site number 28. Instead of constructing on the same, they are constructing the building on 58/A.
Then that is a civil dispute. Go to civil dispute.
Sanction ತಗೊಂಡಿರೋದು.
Civil dispute, civil court ಹೋಗಿ. ಇಲ್ಲಿ ಬರಕ್ಕಾಗಲ್ಲ.
58/A evidence to my property. That's why.
And go to civil court, Mr. Counsel. If there's a different property, we can't deal with it here. Area. Take action against the petitioner also. You constructed 3 floors without even an inch of,
So we are ready.
without even an inch demolition, mud, mud. Or a submission record ಮಾಡ್ತಾರೆ. ಎಷ್ಟು ದಿನದಲ್ಲಿ demolish ಮಾಡ್ತಾರೆ?
The respondent is ready to demolish and also ready. Respondent number 3 and 4.
ಅವ್ರದ್ದು ಆಯ್ತಲ್ಲ, we have notice has been issued. About you, you said you are going to demolish. ಯಾವ demolish ಮಾಡ್ತಾರೆ?
There is a violation by the both the parties. They are constructing newly. My property was constructed in the 1984. They are due to a plan. They are.
ಅದು ನೋಟಿಸ್ ಕೊಟ್ಟಾಯ್ತಪ್ಪ ಅವ್ರಿಗೆ. That will happen.
As per the plan, there are 58/A, only for north side of the wall. There is a staircase is there, right? Not any close the wall.
Whatever it is, you have to bring it in compliance with the plan sanction.
Yes, Your Honor.
That they have issued you a notice. Now you answer there.
Another one open inches of the space, Your Honor, but other side will be set back for on the eastern side and northern side, everything.
This is saying I'll do anything, but nobody else is not acceptable.
Yes, also pending, but evidence
For variation only. To interfere against.
The field inspection report has been filed along with the memo dated 15/12/23. Insofar as respond number 2 and 3 are concerned, it is stated that there's nearly 100% violation. The 100% violation of setbacks on all sides, as regards which notices have been issued under, provisional order has been issued under subsection 1 of section 248. Confirmation order has been issued under subsection 3 of section 248. And further action will be taken by the corporation officials. Insofar as the petitioner is also concerned, the report indicates 100% violation of setbacks on all sides, including 100% violation of coverage, built-up area, and height. That being the case, necessary action would also have to be taken against the petitioner for such violation. Counsel for Shri Pawan Kumar submit that necessary action will be taken given.
The license and building plan already.
ಅಲ್ಲಿ ರಿಪ್ಲೈ ಕೊಡಿ. 248(3) ಆದ್ಮೇಲೆ ರಿಪ್ಲೈ ಅಲ್ಲಿ ಕೊಡ್ಬೇಕಾಗಿತ್ತು. 253 you can avail the.
Come on, the inspection to the spot and they will
2 weeks time to initiate necessary action against the petitioner. Relist on 8th January. Interim order earlier granted is extended till next date. Yeah. In what is the compliance?
You see the distance between the median of the highway and the subject. Because we follow the ground as a national highways. Take action. Let's do a violation. Between the
You're producing it.
producing the course.
Paswara agenda.
Then I produce it along.
And counsel for the petitioner seeks for and is granted 2 weeks time to 2 days time to in what will you sketch along with no objection. Na?
No, along with the sketch of the property. Sketch of the property as regards to design. To see whether the distance between the median and the
Sketch of the property showing the distance from the middle of the national highway. None appears for the respondent, no objection certificate alleged to have been received from the National Highway Authority.
that submission would also be made in the minutes. Instructions are not applied.
Has not been produced. Madam, have you issued anything?
Milord, we don't, Milord, though there was instruction, we have not been served with petition copy, so we have absolutely no idea, Milord. Milord, last date of hearing also, Milord, direction was given, but
Relative serve it. Serve ಮಾಡಿ ಇನ್ನೊಂದು copy.
ಎರಡು ಸೆಟ್ ಅವತ್ತೇ ಸರ್ ಮಾಡಿ
25th January.
That is the opinion and corrected.
Maintainability of the petition. That's the irritated understand. So the both parties are not conflicted, either Taluk Panchayat or Jilla Panchayat. Therefore, I appear before the filed a petition before it comes before. My last is Taluk Panchayat. Officer is entire power of the officer of
Mr. Deol.
appointed of 239.
Administrative officer discharge these functions.
239 class 2 minutes.
If an administrator is appointed. No, administrator is appointed here. Administrative officer ಅಲ್ಲ ಇದು administrator. Administrator.
ಬಾಡಿ ಇಲ್ಲ ಅಂತ ಒಬ್ರು ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿರ್ತಾರೆ. ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಆಲ್ ಫಂಕ್ಷನ್ಸ್ ಏನು ಅಬ್ಜೆಕ್ಷನ್
ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಇದ್ರೆ ಆಗುತ್ತೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಆಫೀಸರ್ ಅಲ್ಲ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಆಗುತ್ತೆ. So administrator has been appointed. You have to go there.
And also 239 power to appoint administrator in certain cases. Any general election to a Jilla Panchayat or Taluk Panchayat under this act.
Submission of Mr. Devraj's administrator has been appointed. We are not looking at the validity or otherwise of the appointment. Nor are you asking about the validity. If the administrator has been appointed, you will have to go to the administrator. Not to this court. He substitutes the president.
That's why you needed to liberty to file a appeal before the petitioner.
Extend that, provided you file it in 10 days.
If I am an administrator is appointed, as per my knowledge, there is no administrator. But if it is there.
If it is not there, you will permit you to revive.
Yes.
Petitioner is before this court seeking for the following leaves. The above petition, the learned counsel for the petitioner submit that the above petition was required to be filed before this court. In view of the office of the president and vice president of the Taluk Panchayat being vacant, and that there being no other ordinary efficacious remedy for the petitioner. K.M.S. Devra, learned counsel appearing for respondent number 2, submit 2 to 5, submit that an administrator has been appointed to the set to respondent number 2 Taluk Panchayat, and in terms of subsection 9 of section 239 of the Section 2 of Section 239 of the Karnataka Gram Swaraj and Panchayati Raj Act 1993. An appeal which was preferable to the president is now to be made to the administrator. As such, the petitioner can approach the administrator by way of an appeal under Section 237. The submission is placed on record. In that view of the matter, I pass the following order. The petition is disposed, granting liberty to the petitioner to file the appeal before the administrator within a period of 15 days from today. If such an appeal is filed within 15 days,
The date of the.
from today, ಏನಕ್ಕೆ ಬೇಕಪ್ಪ? From order copy ಏನಕ್ಕೆ ಬೇಕು? Order copy ಬಂದ
From the date of.
15 days. From today, if such an appeal is filed within the above prescribed time, the respondent not to take any coercive steps against the petitioner, the interim order dated 12/9/2023 shall anyhow to the benefit of the petitioner till then.
Other petition.
ಒಂದರಲ್ಲಿ ನಾವು ಹೇಳ್ತಾ ಇದ್ದೀವಿ till 12 till filing of the appeal. Further interim reliefs to be sought for before the administrator. In the event of no administrator having been appointed, the petitioner is permitted to revive the above petition. Connected matter is 59/23. Interim order date. Pass over. You are for the. What is the office of?
I filed an application to include myself as a travel spot.
Any objection, Mr. Shivkumar?
Not at all. Don't want to take the problem on. They have taken up in violation.
ನೀವು ಹಾಕಿದಿರಾ ಏನಾದ್ರು?
Feel happy, ನಾನು ಒದ್ದಾಡ್ತಾ ಇದ್ದೀನಿ.
ಅವ್ರ ಅಗೇನ್ಸ್ಟ್ ಏನಾದ್ರು ಫೈಲ್ ಮಾಡಿದ್ರಾ ಕಂಪ್ಲೇಂಟ್ ಏನಾದ್ರು?
ಹಾಕಿಲ್ಲ. Because the problem is a very tough person. All the persons in the area are fed up of. In this writ petition, almost.
One sentence.
So there is violation by the proposed respondent also.
My property is in existence from 100 years. Now, he has filed an objection. Along with the objection, he has filed one document at page 18. He says the construction of the property is in existence from long back, but his document says only the off-the building.
Umesh, the existence of a building for a long period of time is a defense for an action against.
I am not taking.
But that cannot be a ground to initiate proceedings like that done in the previous matter or in your matter.
I am ready to face it. This is the second appeal they have preferred before the commissioner.
So you will give up your defense as regards the age of the building. We'll record that.
No, I will take up the defense whenever the notice.
We'll record that. Then you are no business to be here. We'll reject your application.
Yeah, the second appeal is filed by. Petition is for the limited relief. Till the disposal of the appeal filed before the commissioner, stay should be granted. Pilot permitted to participate in the appeal proceedings. I show before the authorities what are the violations.
First, we'll direct an inspection of your property before we consider your application.
Both the properties. There's already a report.
It's already agide, nimdu agbeku.
That report is not placed before this.
You can place it.
Another copy.
Mr. Pawan Kumar will place it.
Another copy.
Impleading application has been filed in IA 1 or 23. Learned counsel for the petitioner submits that though the impleading applicant may be a complainant, there is large scale violation by the impleading applicant also of the building bylaws.
It is constructed after 19.
You see what to do with it. In that view of the matter, before considering the impleading application, respondent number 1 and 2 are directed to carry out an inspection of the property of proposed respondent number 3, bearing number in property details in. Hearing number so and so to ascertain if there is any sanction plan for the said construction. If not, whether the construction is in accordance with building bylaws in terms of setback, height, FAR and permissible use.
As a civil suit, it is filed by me. He has encroached my portion and constructed it. It is pending for at the time of now, it is for the arguments, final stage. There is an encroachment of my property.
That will be decided in that matter.
And if again at the encroachment, non suit hagdaga, if the report says that they have not left the setback.
You being in a glass house, you threw a stone. So the stone is going to hit the glass only. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ.
The report may be placed before this court in respect of the petitioner's property as well as the.
It is already a report.
There is no report in this procedure.
That an appeal is pending before the authority. I am only asking this writ petition, even before the appeal is decided, he issues a notice for demolition. That ground I have come, the appeal is
That
pending.
we have stayed. Inspection report is there as regards to petitioner's property? ಅಲ್ಲ ನೀವು ಅವಾಗ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿದೀರಾ? ಆ ರಿಪೋರ್ಟ್ ಇದೆಯಾ?
Those reports are there.
The inspection report in respect of the petitioner's property. The said inspection to be carried on commencing from 10:30 AM on 29th December 2023. The inspection report in respect of the petitioner's property to be also placed on record. In the event of there being no inspection report in respect of the petitioner's property, number 1 and 2 to carry out an inspection of the petitioner's property on same date as regards so and so. A report to be submitted on 17th January 2024. Objections, if any, thereto to be filed before 31st January, released on 8th February. Interim order earlier granted is extended to this.
Should I have this time next week?
Have some difficulty in sharing the advertisement matters.
Advertisement ಎಲ್ಲ ನೀವೇ ಕೊಡ್ತಾ ಇದೀವಿ.
ನಾನು ನಮ್ಗೆ ಇದಕ್ಕೆ ಅದನ್ನು ಕೊಡ್ತಿರೋ.
ಇವತ್ತು ಇದಾವೆ.
ಅದೆಲ್ಲ ನಮ್ದು ಇವತ್ತಿತ್ತಲ್ಲ ಅದನ್ನು ಕೊಡ್ತೀವಿ. ಪೇಪರ್ ರೆಡಿ ಮಾಡಿ ಕೊಡ್ತೀವಿ ಸಂಜೆ.
And allow that to happen. 21. N.K. Ramesh seeks for and is granted a week's time to file a statement of objections. Released on 20th.
Provisional order was not served. But it was stated. But it really
2022 ಅಲ್ಲ pasted.
22 to 24.
All three pasted. 22 petitioner is before this court, common order. Same order but different order, same. The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the provisional order under subsection 1 of section 248 and notice under subsection 2 of section 248 has not been served on the petitioner. And without such service, a confirmatory order under subsection 3 of section 248 has been passed. Counsel for respondent number 1 to 4 was directed to verify from records and produce necessary documentary evidence to documents to evidence service of notice on the petitioner. That counsel for respondent number 1 to 4, they submit that there is no document to evidence such service, but the notices were pasted on the property. The matter relating to the issue, notices under section 248 of BBMP Act 2020 being serious in nature relating to demolition of a property, and the considered opinion that it would but be necessary for personal service to be effected in such matters. And the respondent cannot, unless it is proved that the petitioner is aware of the pasting of the notice, take shelter on such pasting to contend that notice has been served. In the present matter, no personal service has been effected and there being nothing on record to show that the petitioner was aware of the said pasting of the notice, and the considered opinion that the same cannot be accepted. As such, I pass the following order. Writ petition is allowed.
The act provides for pasting.
You knowledge ಅಂತ ಹೇಳ್ತಾರೆ. That is state that you knowledge of it. If there's something, then yes. The act provides a lot of power to you, but we can't allow that power to be trampled up. Their rights to be trampled up. The confirmatory order challenge ಮಾಡಿದಿರಾ? The confirmatory order dated 15/9/2023 at Annexure F is hereby quashed. The petitioner is permitted to reply to the provisional order within a period of 15 days from today by giving his written submission as also documents in support thereof, which shall be considered by respondent number or in accordance with the applicable law and orders passed. You said that, but that has been stayed by the division bench. Now we cannot rely upon. We held that, but now it has been stayed. Needless to say that until confirmatory orders are passed, no coercive steps can be taken against the petition. Say 22/23.
The board is delayed, the process is delayed.
There is delay in making payment of the process fee. The said delay is accepted. Registry is directed to issue notice to the answer to respond number 4, returnable by 13th February. Report.
That is posted on 12th January.
12th January. Don't get
Inspection ಹಾಕಿದ್ರಿ and some ಕೊಟ್ಟರೆ
don't get served by them. Inspection in ಯಾವಾಗ?
28/12.
Emergent notice returnable by 12th January. Counsel for the petition is also permitted to take out and summons on respond number 3, 4. List on 12th January. You have a lot of office objections.
Applied, my lords, I think there is one submission, that is what it is, I feel.
There is no submission, nothing.
Regards to certain one document which says, I complied it the very next day that I
There are 8 office objections.
complied all the very next day. Very surprised, that is why
There are 11 office objections, you are complied with 3 or 4.
complied.
Still 8. The note put up on.
I understand, but that's-
You don't see it, what do we do? 2 weeks' time is granted to the counsel for the petitioner to comply with the office objection. Relist on 25th January. Criminal records. Hazard drawn up and inspection done.
Because my was false.
But I pass on. Let us find out. Let us find out if that has been done. We will record that and adjourn. Or in our inspection for that. He has to also see it. The counsel for respond number 1 to 3 seeks for and is granted 2 weeks time to produce the original records. Same to be produced on 23rd January 2024, released on 23rd.
Thanks and interim order.
26 interim order earlier granted is extended to next.
Reports. Before time we are searching for, I am paying for some time. We are searching for it.
Searching for it. Service report.
He wants to PO. Without serving the time. They pass the 20th.
Then don't do anything.
Already.
Counsel for respond number 1 to 3 seeks for and is granted a week's time to produce the original records released on 20th. Interim order earlier granted is extended.
No violation except to say that the process adjacent to the drain. He is referring to a secondary drain. Anything, I don't know, ಅದರಂತೆ ದಿನಾಂಕ ಅಂತ ಮೇಲ್ಕಂಡ ಕಟ್ಟಡ ಅಳತೆ ಮಾಡುವ ಕಾರ್ಯವನ್ನು ಅದಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಮಾಡಲಾಗಿದೆ ಯಾವುದೇ ರೀತಿಯ ಪಡೆದಿರುವುದಿಲ್ಲ ಮಳೆ ನೀರು
ನಕ್ಷೆ ಪಡೋದಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು? Not taken a plan sanction.
That is my specific ground. Ultimately, kindly interim order. Not observe there is no sanction plan, but is there any violation?
Yes. So now you'll have to apply for sanction.
That's 148. Right, sir. Sanction plan cannot be given, it's just adjacent to a secondary drain. And it's just 2 meters from secondary drain. It's a huge. Even if they apply for it, it cannot be.
Now, today it cannot be granted.
Buffer zone has to be 12.5 meter buffer zone.
The old construction, when was the construction?
Not old construction, not because the vendor not defend the property and again not when we purchase the property, they have to look for property. Complaint.
By your objections, we'll have to consider this and pass orders. Prayer. Insofar as old constructions, we have said that NGT order will not apply. That also is. Illi plan sanction illa anta distinction madad kashta aguthe. They should also be entitled to the same benefit. It's not troubled anybody till now.
File our objection.
While your objection, that point of an issue will have to be decided. Inspection report has been filed. Is taken on record. The perusal of the inspection report indicates that there's no violation insofar as setback under the building bylaws. However, there is no plan sanction which has been obtained by the petitioner. That counsel for respond number 1 to 3 submits that 1 and 2 submits that even if an application for plan sanction is made now, it cannot be considered in view of the orders passed by the Honorable NGT in OA 114 of 2018. He seeks for and is granted 3 weeks time to file a statement of objections. Objections even need to be filed on or before 25th, relist on 2nd, interim order earlier granted is extended till next date of hearing.
In the last occasion, I was directed to produce the from the fire department and the explosive department, you know. Wrong with application to amend.
So any instructions, madam? ನೀವು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅಂಡ್ ಫೈರ್ ಫೋರ್ಸಸ್ ನಾವು ಮಾಡಿದ್ದೀವಿ. Not made any. Not required. For gas go down, it's not required. But it'll trade fire and emergencies. Fire and emergency service ತಗೊಂಡಿದ್ದಾರಾ?
Earlier, along with the main petition, up to 2027, it is there as per annex area. Other produce model there also annex area. G1, G2. But pass on these things, you know.
From the chief fire officer in 1982 ತಗೊಂಡಿದ್ದೀರಾ?
May I pass on this originally? The action sorry cancel ಅದು. But this elected conditionally.
That has been extended till when? That has been extended till?
Fire officer
ನೀವು ಬೇಕಾಗಿಲ್ವಾ?
From the explosive department. So, G series, A plus G series.
G1 ಏನಿದು?
Is the
Plan.
Is the permission obtained from the chief fire officer Karnataka State Fire Services Bangalore in 1982.
ಎಲ್ಲಿದೆ ಅವ್ರದ್ದು permission?
Next page ಅಲ್ಲಿ ಇದೆ. Original.
The reversal ಇದೆಯಾ?
Reverse.
They have taken the fire services. Explosive cell, the deputy commissioner is not required to grant sanction.
Then we have the license from the explosive department is also obtained field at level.
Mr. Brownie.
Also is
By not to. By safety.
we'll stay it for now. You file your objections. Because there's a fire clearance. Yenu illa ant helidre we would not have. Because it's a gas godown.
Under the subsequent notes documents now, notes under the gas cylinder rules notes are the rules of 2016. Say that it is up to 2020. But not the fire department says notes that that they have not followed the
It's already there.
notes act. These notes a different notes permission altogether.
So let them file their objection also as to what it is.
And one more subsequent notes is that this false notes within the residential area under the master plan.
The residential area has gone up to their,
But however, notes under the zoning regulation, whether notes the commercial activity, to that notes
that is why in your CDP you are aware of it. Any permission granted prior to the CDP coming into force will not be disturbed.
but notes ultimately, so far as the
Your
authority, the development authority notes is concerned.
Correct, but if you are granted a commercial license for the city moved till there. And thereafter, suppose ನಮ್ಮ airport ಇವಾಗ ಹೊರಗಡೆ ಇದೆ. ನಾಳೆ ಬೆಂಗಳೂರಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ರೆಸಿಡೆನ್ಷಿಯಲ್ ಏರಿಯಾ ಹೋಗ್ಬಿಟ್ಟು ಏರ್ಪೋರ್ಟ್ ತೆಗಿಬೇಕಾಗತ್ತೆ.
You will are aware. 10 to 13 notes of the notes where the draft notes master plan will be published before finalizing.
But there is a clause in the CDP that earlier permission will not be disturbed.
But however, not when the residential area is developed, not surrounding this particular property, whether not that could be considered.
Then you will have to
Now,
acquire.
not what they say is that,
Then you will have to acquire. That's the problem. It's a private property.
and this particular property, including the property of notes, the petitioner is shown in yellow color notes as residential use, then notes necessarily they will have to object.
If they have got this permission way back in, when was this?
But 1983 notes.
When the CDP itself was not there. CDP,
Plan note was not there, was not.
CDP cannot impinge on their rights. That way not. That counsel for the petitioner has filed IA 1 of 23 seeking for amendment of the petition by producing certain additional documents. Accepting the reasons stated therein, the said application is allowed. Petitioner is permitted to carry out amendment and file amended petition. 4 weeks' time is granted to the respective respondents to file their respective statement of objections. Considering that there was a fire clearance granted in the year, when was this?
1982. First page ಅಲ್ಲಿ ಇದೆ.
In the year,
First page corner.
ನೋಡಿ, in the year 1982, and there is a license which has been granted under the gas.
Good, sir, that is under the. Initially notes under the Explosives Act. Subsequently notes it is under the gas cylinders rules 2016.
Under the gas cylinders rules 2016. It was notice dated 29/11/2023 at Annexure A. Issued by first respondent is stated the next date of hearing. Objections, if any, to be filed on or before 31st January, released on 9th February. 2014. I issue emergent notice on number 4. Followed by.
Document candidacy annex.
ಐದು objection ಇದೆ ರಮೇಶ್.
ಐದಂದ್ರೆ ಅದೇ ನೋಡಿದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ ಮೂರು ಅಬ್ಜೆಕ್ಷನ್ ಲಾಸ್ಟ್ಮೆಂಟ್ ಕ್ಯಾಂಡಿಡೇಟಿ ಪ್ರೇಯರ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಬರೀಬೇಕಾಗಿತ್ತು ಬರೀಲಿಲ್ಲ ಐ ಕ್ಯಾನ್ ಡೂ ಇಟ್ ನೌ ಇಟ್ಸ್ ಆಮೇಲೆ ನೇಚರ್ ಆಫ್ ಪಿಟಿಷನರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಹೇಳಿದ್ದೀನಿ ಇನ್ಕಾರ್ಪೊರೇಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಬರಲ್ಲ ಯಾಕಂದ್ರೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಕಂಪನಿ ಇಟ್ ಇಸ್ ಎ ಪಾರ್ಟ್ನರ್ಶಿಪ್.
Yes.
Annexes to be strict, readable.
But what is this matter of? What is this matter?
They have issued a notice indicating that more than 20% is there, your commercial activity. That is why I have to close down the business. Lordship, kindly see the annexure D3.
Where is the property located?
Located in Uttarali main road.
After the ring road, before the ring road?
How
Ring road ಆ ಕಡೆನಾ ಈ ಕಡೆ ಆದ್ಮೇಲೆ ಅಂದ್ರೆ ring 3 ಬರುತ್ತೆ.
residential area and Allah. Entire area is non-residential.
It is ring 3. Ring 3 20% is not restricted.
It is that my section that certain restaurants cannot be permitted in residential area. That's why taken. My lordship because with Shanti Bhushan, the case was actually same RR and all that.
But again, the issue is, what is the? That is why we told you also in that matter, they are in ring 3. If it is the same matter, then it is ring 3. Ring 3 amendment ಆಗಿದೆ ಅಲ್ಲ.
Also taking section with regard to rings. The matter is coming on.
That is the matter where Mr. Girdhar had argued on ring 3.
That full matter.
Full matter. But ring 3, the 20% won't apply.
20%.
Other things will apply, but 20% won't apply in ring 3.
Kindly see annexure E.
When are those other matters coming?
Hotel matter is coming on Monday.
Monday.
If Shanti Bhushan service
So this also will have to get connected.
First,
Mandy will permit you to comply with it. If Pawan Kumar accepts notice,
meant once. Anuraga, Anugraha,
ಆಗ ಅದು amendment ಮಾಡಕ್ಕಾಗಲ್ಲ. You have to file a petition because the entry ಆಗೋಗಿದೆ CIS ಅಲ್ಲಿ. Without that, can't make, it'll change ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ change ಆಗಲ್ಲ. If Pawan Kumar accepts notice for respond number 1, 2, 3. Also for the petition is granted 2 weeks time to comply with the office objection. The operation of
A1 to 3. Which kindly have it on Monday.
till Monday will stay so that the operation of annexures A1 to A1 and A2.
Yeah.
Objection raised. A1 state till the next date of hearing, relist on Monday, 19th, 18th.
Connect with
WP. Office objection, we may kindly go over.
Connect with WP
23065.
23.
Reliable.
You check on ring 1, ring 2 and ring 3. Where is the location? Ring 2 ಒಳಗಿದ್ರೆ 20%. Ring 2 after ring road ಆದ್ರೆ inside the ring road CBD is ring 1. CBD to ring road is ring 2. After ring road is ring 3. Ring 3 ge your road width is required, but not the extent of use. So that you make your submission. Recall application ಗೂ ನೀವು ಬಂದಿರಲಿಲ್ಲ. IA has been dismissed. What IA 1 and 2, 1 of 23 ಏನದು? ಅದು recall. Dismissal, recall application dismissed to recall application dismissal. Why was the petition dismissed? Office objection has still not complied. The 20th April 22 office objection not complied and dismiss ಆಯ್ತು. ಅದಕ್ಕೊಂದು IA ಹಾಕಿದ್ರಿ. ಅದು IA dismiss ಆಯ್ತು. Recall application. You are adhiki non recall. You comply with the office objection first. Pending compliance with the pending consideration of IA3 of 23. Counsel for the petitioner is permitted to comply with the office objections. Relist on 29th January.
What one actually? I have filed my objection in this case, my lord, for recall. The application, they have mentioned that the matter was called in the forenoon and they were arguing. They sought for an adjournment at 1:30 p.m. and the senior counsel objected to the same, and the matter was taken up at the afternoon at about 30. Petitioner's counsel was not present, and therefore it was dismissed.
Correct. They
have not produced any evidence to show that they will end up in portal number 8 and which matter was.
ಹೇಳಿದಾರು ನಿಜ ಆದ್ರೂ ಹೇಳ್ಬಾರ್ದು.
They also did not try to recall on the same day also, my lord.
ನಿಜ ಹೇಳ್ಬೇಕು. ಅಪ್ಲಿಕೇಶನ್ ನಿಜ ಇಲ್ಲ ಅಲೋ ರೀಕಾಲ್ ಅಪ್ಲಿಕೇಶನ್ ಸುಳ್ಳು ಯಾಕೆ ಹೇಳ್ತೀರಾ? When was it dismissed? It was dismissed in the afternoon session, not in the forenoon session. ನೀವು ಹೇಳ್ತಾ ಇರೋದು forenoon session ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ನೀವೇನ್ ಬರ್ದಿರಾ ಓದಿದೀರಾ ನೀವೇ? ಫಸ್ಟ್ ಓದಿ ನೀವು ಬರ್ದಿರೋದು ಓದಿ. ರಾಂಗ್ ಇದೆ. ಆಫ್ಟರ್ನೂನ್ ಮಧ್ಯಾಹ್ನ. ಇದು ಸುಳ್ಳು ಹೇಳೋದಕ್ಕೆ ಕಾಸ್ಟ್ ಎಷ್ಟು ಆಗ್ತದೆ? ಡಬಲ್ ಕಾಸ್ಟ್ ಆಗ್ಬೇಕು. ವರ್ಡಿಂಗ್ ಗೊತ್ತಿಲ್ಲ, ಏನ್ ಬರ್ದಿರೋ ಅದೇ ನೋಡೋದು. ಎಷ್ಟು ಕಾಸ್ಟ್ ಎಷ್ಟು ಹಾಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಯಾವಾಗ ರೆಡಿ ಆಗ್ತೀರಾ?
After vacation, date may be fixed, my lord. Senior counsel will argue the matter.
T21. Accepting the reasons stated in support of IA2 of 23, the order dated 21/11/23, dismissing the above petition for non-prosecution is recalled. The petition is restored to file subject to payment of cost of rupees 5,000 to the advocate's clerk's benevolent fund. The said payment to be made within a period of 10 days from today. Relist on 22nd January. Interim order earlier granted is extended. Who wants to come on record? 1 of 22 ಯಾರು ಹಾಕಿರೋದು? MB Anil Kumar. Not served a copy. Who is proposed? Respond number 7. Who are you? Yaro.
I am a member of the society.
Why do you want to come on record? What is your interest to come on record, Mr. Counsel?
We have collected certain documents in respect of the petition. Because the two officers.
So you can collect it and keep it with you. What is your interest?
The society is in loss. Only the two officers. And one of the member of the society.
The society is going a loss in which you are a member of. Yes. Yes.
Is a member of the fifth respondent society. Society is representing here. Society is submitting the things. Including the report.
He's saying that both of you are colluding, therefore the interest of society is up.
Society is sufficient to defend the things.
Society is not defending and ಅವ್ರು ಹೇಳ್ತಾರೆ.
We have no local standing to make submission. Maybe he has submitted a complaint to the authorities. Authorities also hear a parties. Whether I am holding a true post or not. Whether I am permitted to contest in the elections or.
We'll permit him to come on record as an intervener. You submit the papers. You won't have a right for audience. Whatever documents you have collected, you place it on record. Documents kotre, society will argue on it. I-1 of 22 has been filed by a member of the fifth respondent society to come on record contending that due to the actions of the petitioner, the respondent number 5 society has been adversely affected. His submission is that he has certain documents which he wishes to place on record, which has already been placed on record. You have already placed it on record, Allah, along with the impleading application. It is already placed on record along with the impleading application. In that view of the matter, I am of the considered opinion that the petitioner is not a proper necessary party to the proceedings, but could be permitted to assist if required, assist this court if required as an intervener. Hence, respondent of proposed the impleading applicant in IA-1 of 22 is treated as an intervener. Yes. All pleadings are complete? You have filed your objection. 5. Respondent number 1 in Sarvagil. Counsel for the petitioner is directed to serve a copy of the petition along with annexures on the counsel for respondent number 1 by end of day 20th December. Objections to be filed on or before 25th January, released on 5th February. Take it up for hearing and dispose it. Interim order earlier granted to the extent.
Only not to filing on affidavit. I'm going to fill the affidavit.
3823 has not been.
Which are covered in the admission. First. Can you recall the order of the?
What do you have to? Primary statute and subordinate statute for Dharamshala.
I'm good. I restrict my service. And also I confess. Not to participate, put up any programs like whatever my friend is. Respondent objection on with document. The document clearly I saw that there is a wedding ceremony is also involved. Now I am going to give up all those things.
Can you put up a Dharamshala in this area? It's a residential area.
Residential zone.
It's a residential zone.
Commercial.
Restrict ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಆಗಲ್ಲ. R1 alva, main residential main. And what are the permissible activities?
Permissible activities permissible activities.
Yen permissible.
There is an hostels are permitted. Annexure J may not be mixed.
C2, R and T1 are permissible uses.
And I in my affidavit, I clearly state that.
The R and R, T1 are permissible land use for the entire property. You are not asking for ancillary use, you are asking for main use.
Religious, smartly,
Are you permitted to do that under category R, classification R? Plotted villa, apartment, multi-dwelling, group housing, ashte baradu. Adu bitre T1.
There is a permissible activities I can commit. Otherwise, I don't want to perform any one of the.
All the things that you have stated here are not permissible. Illa, barala. Show us where it is permissible.
Yeah, 67 in my petition. Say number 3 minutes.
67.
67.
the connection with Gmail. Now number 3. Residential land users, my last in this case. In that case, say number 3, apartments, hostels, permission. These 3 I am
ಇದು ಯಾವ್ದಿದು?
of the revised master plan for 2015. Zonal of land use and regulations. Approved by government of wide order number 6.
ಧರ್ಮಶಾಲಾ.
Our plan is.
So ಧರ್ಮಶಾಲಾಗೆ ಏನು? What are the?
Hostels also. And free education.
What are the uses?
Religious works means naming ceremony, naming ceremony, small functions can be, we can.
What are the uses for ಧರ್ಮಶಾಲಾ, Mr. ಯಾವ ಪ್ರಾವಿಷನ್ ತೋರ್ಸಿ? ಪ್ರಾವಿಷನ್ ತೋರ್ಸಿ. ಇವಾಗ ತೋರ್ಸಿದ್ರಲ್ಲ ಹಿಂಗೆ ಪ್ರಾವಿಷನ್, ಅದಕ್ಕೆ ಪ್ರಾವಿಷನ್ ತೋರ್ಸಿ.
Concept is a commercial building. And he has given the property, the building for residential activity, the commercial activities. I have placed material for this court, my lord. Even advertisements also I have filed update.
Regarding
Mission is
all those things.
ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ, ನೀವು ಸುಮ್ನೆ ಮಾತಾಡ್ತಾ ಇದ್ರೆ ಆಗಲ್ಲ. Now the submission is Dharmashala is what he wants to restrict. What are the Dharmashala uses ಅಂತ ಏನಿದೆ ಇದು? There's amended this one as Dharmashala.
Page number 61, my lord. It is before entering the plan.
ಇದೆಲ್ಲ ಹೋಗುತ್ತೆ. Whatever they have done here. But Dharmashala ಆದ್ರೂ
ಏನೇನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಬೇಕಾದ್ರೆ conducted ಧರ್ಮಶಾಲಾ.
ಇದು ಮಾಡೋದೆಲ್ಲ ಹೋಗುತ್ತೆ. But what is the Dharmashala use? What is the classification? ಬರೀ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ ಸುಮ್ಮನೆ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ ವಿತೌಟ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್. Which provision would Dharmashala come?
The Dharmashala, like I search for.
ಧರ್ಮಶಾಲಾ.
I gone through the DBMP Act regarding license 305 and onwards. But there is no mention of Dharmashala. CDP clearly state.
ಧರ್ಮಶಾಲಾ ಅಂತ ಇಲ್ಲೂ ಇಲ್ಲ. ರೆಸಿಡೆನ್ಷಿಯಲ್ ಜನ ಧರ್ಮಶಾಲಾ ನಡೆಸಬಹುದು ಅಂತ BBMP Act ಅಲ್ಲಿ ಹೊಸ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ.
ಬಟ್ RMP 2015 ಅಲ್ಲಿ ಧರ್ಮಶಾಲಾ ಅಂತಿದೆ ಅಲ್ಲ, 6 ಅಲ್ಲಿ
Your license ಕೊಟ್ಟರು ಅದಕ್ಕೆ
ಅಪಾರ್ಟ್ಮೆಂಟ್ಸ್, ಹಾಸ್ಟೆಲ್ ಅಂಡ್ ಧರ್ಮಶಾಲಾ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ.
Have this better by next week. I will come with certain information from the concerned person because the petition was dismissed. I send back entire file to the corporate.
Right.
I could not have a file right now.
Shri N.R. Jagdishwara, Learned Counsel for the corporation, seeks for and is granted a week's time to make a submission as to what are the uses, what are the permissible land uses insofar as Dharmashala is considered, which comes under item number 3 of residential land use, released on 20th. ಬಿಡೋಣ, ಇಷ್ಟು ಸ್ಪೆಂಡ್ ಮಾಡಿದ್ರು, ಬರೀ ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಆಗೋಯ್ತು.
Okay.
ಸಶರರ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು? ವಾಚಿಂಗ್ ದ ನೋಟಿಸ್.
They wanted to pay the
Right. If they sought for 3 months, directed them to file an undertaking affidavit. After that, they should have. But if they have not, they participated in the bid, they themselves bid the amount of 14,300.
Yes.
100 and 5,017.
They wanted to pay it in installments.
Pay in installment, then undertaking they have to.
ಎಷ್ಟು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ಸ್ ಕೊಡ್ತೀರಾ? 4 installments. Every month, every second month ಹೆಂಗೆ? ಒಂದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಹಾಕ್ಬೇಕು ನೀವು.
The last city it was posted only silent. How they was.
16 months. But in the shop.
ಫೈಲ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಆಫ್ ಯುವರ್ ಕ್ಲೈಂಟ್. ನೀವ್ ಹೇಳ್ಬಿಟ್ಟು ಇದು ಮಾಡಬೇಡಿ, ಅವ್ರ ಅಫಿಡವಿಟ್ ಹಾಕಿ. That counsel for the petitioner submits that the petitioners are willing to make payment of the amount which was bid by them in 4 installments. She seeks for and is granted 2 days time to file an affidavit of the respective petitioners. Relist on 19th.
Instead of 1920.
20th. Monday ಒಳಗೆ ಆಗಲ್ಲ 20th. Interim order earlier granted is extended. Yes. Yes.
1960 Deputy Commissioner recommended to verify the lands in and surrounding of the Srirampura Gram Panchayat to allot the sightless person, the village panchayat, and 1960 issued a letter. On the basis of letter, the land has been identified in the Karab land and allotted the site in favor of the petitioner's hearing on 8/4/1974. Now the property and they have issued a license for put up construction and also issued a kata also, and they have paid taxes. Now the property comes under the jurisdiction of the Mysore City Corporation. Now saying that the property is in B Karab, you can't accept the kata and we can issue the kata in your favor. They issued a endorsement and next year EMI. Page 20.
What about 1960 allotment has been made.
The contract. So now, there is an absorption, comes to the.
Aren't you bound by your predecessor's action? How can you now say that it's weaker of once? Allow the petition. In all the above matters, the petitioners are before this court, seeking for the following reliefs. Each of the petitioners claim to be in possession of a site in a layout formed by the group Panchayat Srirampura in Kopluru village, Kasba Obli, Mysore Taluk. More particularly in survey number 39/1A. Allotment had been made in their favor on 22, the Special Deputy Commissioner having permitted the usage of land on 22/1960, allotment was made in favor of the petitioner and certain others. On 8/4/1976. The petitioner's predecessors on 8/4/1976. From which time they have been in possession thereof. An application for construction having been made, a license was issued on 5/1/1983. The construction was completed. Kata was issued and thereafter a e-kata was also issued. Some of the original allottees have sold their properties to the petitioners. Some of the petitioners have succeeded to the estate of the allottees, being their legal heirs. The details of each of the matter may not be required to be gone into in the present matter. Suffice it to say that while endorsement dated 9/10/2023 issued by the respondent number 1 corporation, respondent number 3 corporation, land in survey number 39/1A, which has already been put to residential use, was sought to be reclassified as B Karab land as if it continues to be an agricultural land. And it is in that background that the petitioner is before this court seeking for the opposite relief. The property, the counsel for the petition submit that the property comes within the urban agglomeration of the city of Mysore and comes in the jurisdiction of the Mysore City Corporation. The same has lost its agricultural character and therefore is no longer agricultural land for a classification or a portion thereof to be made as B Karab. And as such, respondent number 2 could not have addressed a letter, issued an endorsement to the petitioner stating that the land would be reclassified as B Karab.
It's forthcoming from the endorsed petition.
Sorry?
The absorption is forthcoming.
It's also why has he issued this? Now, these grounds you submit that the above petition is required to be allowed. Now, petitions are required to be allowed. What is your submission in this? That counsel for respondent number 2 and 3 submit that the endorsement issued by respondent number 2 is proper and correct since the land was originally a Karab land. Or so and so various papers. It is not in dispute that the property comes within the urban agglomeration within the jurisdiction of the city corporation. It is also not in dispute that the allotment has been made to the petitioner's predecessors and constructions have been put up on the said property. Khata has been issued by the corporation as regards which taxes have been paid. These are all reflected in the endorsement, impugned endorsement dated 9/10/2023 at Annexure A. In fact, the endorsement is also issued to the petitioners. That being the case, the question of the zonal commissioner after the land having come into the jurisdiction of the corporation, contending that the land is B Karab on the basis of the classification in the year 1960 would not arise. As such, I pass the following order. Writ petitions are allowed. The impugned certiorari is issued. The impugned endorsement bearing number so and so dated 9/10/2023 at Annexure A are hereby quashed. A mandamus is issued directing second respondent to continue the assessment of the property as city property and collect taxes in respect of the kata already issued in favor of the petitioners. If you want to connect to on the same one.
Industries are two different. Only 24/5 ಇದೆ ಎರಡು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇನ್ನೊಂದರಲ್ಲಿ 9/10.
Yes.
The number 68.
Copy is taken in the 75 days.
What is the review that you are seeking for?
The distribution of annexure approval. Annexure to the order of dismissal.
What is the review you are seeking for? Review of a dismissal order. You did not take out notice to the respondents and you wanted dispensation.
Second is respondent number 3. I filed an application for dispensation, my lord.
Yes. And you wanted to obtain an order behind their back without issuing notice.
They are not, and if your lordship orders, I will take them.
That is what was observed. Option was given to you.
Now I will.
Dismissal ಆದ್ಮೇಲೆ ಎಂತದಿದು? You expressed your malifides at that time. The malifides were noticed and dismissed.
So the petition, my lord, I will take notice to all the reports.
Why should we restore when you are malified? Your bona fide will always help you. If you are malified, we won't.
No, before filing the petition, after filing the petition, my lord, I sought a dispensation, my lord. And
You can't seek for dispensation.
It is annexed 3, my lord.
You cannot ask for dispensation when the order is going to affect them. That is what was pointed out.
No, even in the first petition, my lord, it is annexed Q, my lord. It is annexed Q, annexed O and P. That is the annexed P, my lord.
Make sure.
Annexed P.
Yes.
I sought for a dispensation for issuing notice to respondent number 3 and 4.
Yes, we understand. 3 is a private party against whom the order is going to affect.
Here is the authority. Our respondent number 2. Respondent number 2, my lord, arbitrarily entered the name of the authority and.
How much costs are you going to pay? It better be a good cost. Your actions have been completely malified, so it'll have to be high cost. ನೀವು ಹೇಳ್ತಿದ್ದ ನಾವು ಹೇಳೋದು. ರಿವ್ಯೂ ಪೆಟಿಷನ್ ಬೇರೆ ಹಾಕಿದ್ದೀರಾ. ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಬೇಕು. You can't allow it. Issue notice.
Number 3 was made as a party.
Learned AGA accepts notice for respondent number 1 and 4. Legal error. A. Nagarajappa is director accept notice for respondent number 2. Issue notice to respondent number 3 on IA 1 of 23, returnable by 14 February.
Gudi village. Jointly, it is right now place. And purchase then it's 8,000 tax, including branch stamp there. And got registered it before.
How are you concerned with this?
Briefly of this survey number.
You are a resident of that area.
My survey number.
File a PIL. File a PIL. You can't use this as a.
Last flood, in the last flood, because
I think file a PIL. It can't be a private interest litigation. If you want to file a PIL. Comply with all the requirements.
it seems my property is affecting over the overflow water. Kindly see the photograph. And the annexures.
Adjacent land ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ? What is your survey number? ನಿಮ್ ಸರ್ವೆ ನಂಬರ್ ಏನು?
My survey number is 75. 73/3.
73 ಇದು 87 ಇದೆಯಲ್ಲಪ್ಪ.
Next in continuation of this Rashtralia, immediately after deep survey.
Are you adjacent or are you later?
Are you late? My property is next later.
ಪಕ್ಕದ ಪ್ರಾಪರ್ಟಿನ ದೂರ ಇದೆಯಾ?
ಮುಂದೆ
ದೂರ ಇದೆ ಅಂದ್ರೆ PIL ಆಗಿ. ಪಕ್ಕದೇ ಅಂದ್ರೆ we could consider ಕೆಲಸ. ಇಲ್ಲಿ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? Where is your property in Annexure B?
only after the
ಮಾರ್ಕ್ ಮಾಡ್ಕೊಡಿ ಎರಡು ಪ್ರಾಪರ್ಟಿ ಯಾವುದು ಪೆನ್ಸಿಲ್. ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಅಂಡ್ Password ಮಾಡೋದ ಅರ್ಜೆಂಟ್ ಮಾಡೋದ ಪಾಸ್ವರ್ಡ್. Remove 6% from, to remove the sixth respondent. What is your annexure there?
Because for the Panchayat Act, the elected member or release the fund or allot the works to the relative. Here what happened was from 2000 is the date. I have given it several representations.
Who are you?
I have the villager and I'm
Public interest. You can't use this.
43, it clearly says your losses if at all and
You are some samiti. You're not an individual. No personal interest.
I have produced before the honorable court as it clearly shows.
Fair enough. It's not a personal interest. Dismissal, liberty, conversion.
Memo along with the hearing set you also like 1 week time also.
Of the above petition would indicate that is more in the nature of a public interest litigation. There is no private interest litigation involved. Private interest involved. That counsel for the petitioner seeks permission to convert the above matter into a public interest litigation. Same is granted. Petitioner to comply with the requirement of the public interest so-and-so rules. Once complied, raised at judicial to place it before the appropriate bench.
Bill which has been raised and payment not been paid. Everything in the guideline, there was a special investigation being constituted. For works from 2019,
There is no interim prayer. There is no interim prayer.
There is, in fact, there is an undertaking that the petitioner is given. If to the coordinate things, where I said, I not facilitate the matter insofar as the payments are concerned because the lady had the order.
There is no interim. We have to only direct notice. That's all. Pawan Kumar,
There are 7 matters, pertaining to different works in giving the supposed to be 90.
Pawan Kumar accepts notice for
All matters are given to SH Prashant.
the SH Prashant is directly accept notice for respond number 1 to 4. Connect the above matter with so and so and relist on 19th. For the petitioner to furnish 2 sets of the petition along with annexes on the said council.
Madam, I have challenged the order possible number 2, executive officer, all of them. Now. Pretty sure of the petition.
Cancellation of e-sottu. Yes.
Who the accused person has to challenge the order within 30 days as per the section 2. The challenge after lapse of 5 years. Moreover, is not an accused person, the person, the what effort they challenge that has not been person.
Yes. The HCGP accepts notice for respond number 1,
1 month.
BJ Soumyaji for 2, 3 and 4. Issue notice to respond number 5 returnable by 16th February. The operation of the impugned order bearing number so and so dated 7/11/23 and appeal number 6 of 22/23. Where respond number 2 at annexure M is stated till the next date of hearing. Those 3 copies to be furnished by end of day tomorrow, failing which the interim order will stand automatically vacated.
Information page number 36, Mr. G.
Who is your construction?
And the address,
Present. How is your construction? Nim construction ಹೇಗಿದೆ? Clear ಆಗಿದೆ.
this is photograph.
Inspection ಮಾಡ್ತೀವಿ ಆಮೇಲೆ ನಿಮ್ದು violation ಅಂದ್ರೆ it will be a problem. Pawan Kumar accepts notice for respond number 1 and 2, issue notice to respond number 3 written up by 14th February. Respond number 2. The right to cause the inspection of the property of the petitioner. Any property number in? Property address in. Hindu. You are 24. Property number is 24. Nimma property number ಏನು respond number 3 property number ಏನು?
24 is my property.
Respondent to 7 ಅಂತಿದೆ. How can you be adjacent?
3. Number 23 ಅಂತ.
Number 24 7 ಪಕ್ಕದ ಆಗಲ್ಲ. ಪಕ್ಕದ ಹೆಂಗಾಗತ್ತೆ? ವೆರಿಫೈ ಮಾಡಿ ಪಾಸ್ ಓವರ್. ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ ಫೋನ್ ಮಾಡಿ ಚೆಕ್ ಮಾಡಿ. 43 at the request of counsel for the petition released on Monday. Let issue notice. Let SCGP accept notice for respond number 1 to 4. Include Municipal Corporation, Sakshi Krishna for 5. Special Administration Officer State Allah. The SCGP for 6, 7 and 8. 35 Sakti Krishna. Counsel for the petition served 2 sets of the petition along with annexation of the said counsel. Objections, if any, by 31st January, released on 9 February. CG accepts notice for respond number 1. AV Gangarappa for respond number 2. Shumaga Bhandravati. Yes.
Directing the respond number 2 and 3 to consider the representation of page number 20 and 23.
Very important issue. Surrogate mother's name has been inserted in the birth certificate, not the genital. ಯಾರ ಹೆಸರು ಆಡ್ ಮಾಡಿದ್ದಾರೆ ಇದು? Whose name has been added?
The name of Shailaja Mishra.
Who is Shailaja Mishra?
She is said in the petitioner's wife. The surrogate agreement entered between them. No, surrogate mother name is not there.
Shailaja Mishra, whose name is erroneously mentioned in the birth certificate.
The notification pending for the petitioner, the respondent and performance.
Whose name is to be entered now? To be left blank. No mother's name.
Pass on the single.
It's an important issue, but you are misusing this forum. Pass over. Accepting the reasons stated in IA 1/23, so and so dispensed with the annexure. See, connect with so and so. Connect.
Layout, you know, say, on 30th/11/2022, layout plan is sanctioned in favor of vendor of my claim. The petitioners. Subsequently, they have sanctioned one more plan where street alignment is not there. We made a complaint telling when the provisional layout plan had been sanctioned, we made a representation telling this is street alignment is not there. They gave a notice telling that we are going to inspect the property. They did not inspect the property.
Where is the plan?
Sanction plan, which are challenged is an agreement.
Street alignment is there. Street alignment is there.
Your last, I will show me that. Your last may kindly come to page number. I have taken out the Google map. Your last may kindly see. Right. 127 onward, 3 maps I have produced. Round ಹಾಕಿದ್ದೀನಿ earlier. Road ಇದೆ. ಅಲ್ಲಿ continuation road ಇದೆ. 236 provides that access should be given to its property as well as adjacent properties. ಏನಾಗ್ತಿದೆ ಅಂದ್ರೆ your last may kindly have a look at page 115. ನೀರ್ accumulate ಆಗಿದೆ 115 photograph your last may kindly. ನೀರೇ ಹೋಗಲ್ಲ. ರೋಡ್ ಸಿಂಕ್ರನೈಸ್ ಆಗಿದೆ, ರೋಡ್ ಕೆಳಗೆ ಚರಂಡಿ ಕೆಳಗೆ ನೀರು ಹೋಗೋದು. ನೀರು ಹೋಗಕ್ಕೆ ಪ್ರಾವಿಷನ್.
So your layout is A and B.
In schedule A, my layout is there.
ಇದು annexure Q ಅಲ್ಲಿ.
Annexure
Q.
Yes, my lord. What is shown on the left side is my layout. That is from round ಹಾಕಿರೋದ್ರಿಂದ.
Which was granted first?
My layout is granted first. In fact, original layout itself is sanctioned subsequent. If you are large to I mean, our representation could be either
Authority may not be able to decide this one. But the point raised by Mr. Dwarkanath is important in terms of the synchronization of the roads doesn't happen. There's no synchronization of any road here. Order. That is for their own, plan. The person aggrieved by, but your authority will not be able to decide on this. Annexure Q node, page 127. Map it. ಲೆಫ್ಟ್ ಸೈಡ್ ಇರೋದು ಆಲ್ರೆಡಿ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಅಪ್ರೂವ್ಡ್ ಲೇಔಟ್, ರೈಟ್ ಸೈಡ್ ಇವಾಗ ಹೊಸ ಲೇಔಟ್ ಕೊಟ್ಟಿರೋದು. ರೋಡ್ ಅಲೈನ್ಮೆಂಟ್ ನೋಡಿ, ಸಿಂಕ್ರನೈಸೇಷನ್ ಇಲ್ಲ. This road will go and hit a house.
Page 125 ಒಂದು ನಿಮಿಷ. Page 120. ನಾ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟೆ 123 ಪ್ರಕಾರ. ಅವರು ಲೆಟರ್ ಬರೆದ್ರು, ನಾವು ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು. ಇವ್ರ ಲಾಸ್ಟಿಪ್ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು 125. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ನವನೀತ್ ಕುಮಾರ್ ಸಿಂಗ್ ಎಕ್ಸೆಟ್ರಾ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಸ್ತಿತ್ವದಲ್ಲಿರುವ ರಸ್ತೆ ಮತ್ತು ನಾಲಾಗಳನ್ನು ಪರಿಗಣಿಸಿರುವುದಿಲ್ಲ. ಮಳೆ ನೀರು ನೈಸರ್ಗಿಕವಾಗಿ ಸದರಿ ಬಡಾವಣೆಯ ಮೂಲಕ ಹರಿದು ಕೆರೆಯನ್ನಿರುತ್ತದೆ. ಇದರಿಂದ ಮಳೆ ಸಮಯದಲ್ಲಿ ಸುತ್ತಮುತ್ತಲಿನ ಪ್ರದೇಶದಲ್ಲಿ ಪ್ರವಾಹ ಉಂಟಾಗುವ ಸಾಧ್ಯತೆಗಳಿರುತ್ತದೆ. ಸದರಿ ಬಡಾವಣೆಯಲ್ಲಿ 40 ಅಡಿ ರಸ್ತೆಗಳನ್ನು ಮುಂದುವರಿಸಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಈ ಆಕ್ಷೇಪಗಳನ್ನು ಪರಿಗಣಿಸಿ ತಾತ್ಕಾಲಿಕ ವಿನ್ಯಾಸ ಅಗತ್ಯ ಏರ್ಪಾಡು ಮಾಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ಇದಕ್ಕೆ ಅವರು ಮೇಕ್ ಅನ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಅಂತಾರೆ. ಇನ್ಸ್ಪೆಕ್ಷನ್ಗೆ ಬರೋಲ್ಲ, ಅವರೇ ಬರಬೇಕು.
The drain will not flow forward. ಅಲ್ಲೇ ಸ್ಟಾಪ್. ಅದು ಹೋಗ್ಬಿಟ್ಟು ಆ ಮನೆ ಯಾವ್ದು ಮನೆ ಅಲ್ಲಿ ಕಟ್ತಾರೋ ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಮಾಡುತ್ತೆ. ಅಲ್ಲಿ 4-5 ಸೈಟ್ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೋ ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. ಇಲ್ಲೂ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. Should not it be an obligation for the subsequent colonizer who wants to create a colony to see what is in existence and then work it accordingly? The rules applicable to.
Kharab and other is concerned, my lord. Revenue authorities, what is they said, my lord, we will.
ಇದು ಖರಾಬ್ ಅಲ್ಲ ಇದು.
But my lord, Hindu oil, my lord, kindly, my lord, page number 127.
ಮುಂದುವರೆದು
ಮುಂದುವರೆದು ನಮಗೆ ಖರಾಬು ಇರುತ್ತೆ. ಹೇಗೆ ಖರಾಬು ಎಂದು
that is incidental. That is another issue. ಒಂದು ಲೇಔಟ್ ಇಲ್ಲ ಆಯ್ತು, ಇನ್ನೊಂದು ಲೇಔಟ್ ಇಲ್ಲಿ, ಆಮೇಲೆ ಇನ್ನೊಂದು ಲೇಔಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. If none of them are connected, traffic flow will get affected, water flow will get affected.
ವಾಟ್ ಅಪ್ ಮಾಡಿ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆಫ್ ಡಿಸ್ಟೆನ್ಸ್ ಆ ರೋಡ್ ಬಂದ್ರೆ ಹಂಗೆ ಮುಂದೆ ಕಂಟಿನ್ಯೂ ಮಾಡಬೇಕು ಅಂತ
ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ. So what are the rules applicable to that?
17(2)(a) is there, my lord, that section.
ಅದು ಇಂಟರ್ನಲ್ ರೋಡ್ಸ್ ಅಲ್ಲ. Should be synchronized with the other ಅಂತ ಇದೆಯಾ?
ಅಲ್ಲ, 17(2)(a) not visiting.
Sanction layout plans and solution.
Street alignment clearly specified.
No, it doesn't say that it has to synchronize with the next layout.
If the authority decides to sanction the layout plans under subsection 2, it shall sanction provisional layout plan in accordance with such rules as may be prescribed for demarcation development purposes, showing the sites, street alignment. Street alignment necessarily means
Street alignment ಅಂದ್ರೆ ಆ ಲೇಔಟ್ ಅಲ್ಲ, ಪಕ್ಕದ ಲೇಔಟ್ ಅನ್ನಿಸ್ತಾರೆ ಕಣ. That's the problem. Within that layout they have shown it. Please understand it.
Street alignment within that country.
Street alignment has to be aligned in the layout being sanctioned also.
Also,
Is
but
it-
also with the adjustment.
Where is the rule which says for the?
Kindly come to the rule 36, rule 36.
Rule 36.
Running rules and rules 3665.
Yes.
Every person submitting plan and subsection 12, etc., is keep up. 2. Site plan showing the existing access to the land included in the layout and the surrounding lands. What I have found is, if they were to remove 2 sides, ನೆಟ್ಟಿಗೆ ಕೊಡದೆ ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿರೋ ಒಂದು ಈಸ್ಟ್ ವೆಸ್ಟ್ ಹೋಗ್ತಿರೋ ಚರಂಡಿ ಕೊಟ್ರೆ ಸಾಲ್ವ್ ಆಗತ್ತೆ. ಈ ದೇ ಹ್ಯಾವ್ ಟು
ಅದು ಸಾಲ್ವ್ ಆಗಲ್ಲ. That road has to go till the end.
ಸರಿ, ಅದು ಆಗ್ಲೇಬೇಕು ಅಂತ ಅವ್ರ ಲೇಔಟ್ ತೊಂದರೆ ಆಗದೆ ಇರ್ಬೋದು ಅಂದ್ರೆ 2 ಸೈಡ್ ಮಾಡ್ಬಿಟ್ಟು ಇರೋ ಚರಂಡಿ ನಾವು ಕನೆಕ್ಷನ್ ಕೊಡಕ್ಕಾಗಲ್ಲ.
Stop gap arrangement ಆಗಲ್ಲ. It has to be. What are the rules applicable to this? Because even what rule 36 is not very clear on that. To have access ಅಂತ ಹೇಳಿದ್ರೆ access ತೋರಿಸ್ಬಿಟ್ಟಿದೀವಿ ಅಂತಾರೆ. If the roads have to synchronize, what Ms. Dwarkanath said first is correct. It has to be synchronized. The drains have to be synchronized. The electricity lines have to be synchronized. If the drains are not synchronized, this is one other reason. ನಮ್ಮಲ್ಲಿ ನೀರು ಇದಾಗದು. ನಾಳೆ ಇಲ್ಲಿ ಮನೆ ಕಟ್ಟಿದ್ರೆ ನೀರು ಹೋಗಿಲ್ಲ ಅಲ್ಲಿ that site will get flooded.
Slope ಇದೆ, natural slope.
That is what we have directed in that other matter of the corporation to do the study on that. Delay clearly apparent. If you sanction like this, there's no way that that water can flow. Traffic, it will come hit that wall and ಆಮೇಲೆ ಏನ್ ಮಾಡ್ಬೇಕು?
ಇದೆ ಎಕ್ಸಸ್ ಹೆಂಗಿದೆ ಅದನ್ನ ಹಂಗೆ ಮುಂದುವರಿಸಬೇಕು ಅಂತಾನೆ ಹೇಳೋದು.
ಯಾಕೆ ಮಾಡಿಲ್ಲ ಅದ? ಯಾವ ರೂಲ್ಸ್ ಇದೆ ಅದು ಕೊಡಿ, ವಿಲ್ ಸ್ಟೇ ದಿಸ್ ಫಾರ್ ದೆಮ್. ವಿಲ್ ಸ್ಟೇ ದಟ್. Article planning ನೀವೆಲ್ಲ Shri Yogesh Naik accept notice for respond number 1 and AG accept notice for respond number 2 and 2. Yogesh Naik for 1 and 4 alla? 1 and 4. AGA for respond number 2. Issue notice to respond number 3 returnable by 15 February. The operation of the grievance of the petitioner is that the road alignment, the road, the layout which has been sanctioned in favor of respond number 3 does not synchronize with the already existing layout of the petitioner in terms of the existing roads, drains, etc. Resulting in the free flow of water in the drains being curtailed, hence further resulting in flooding of the sites in the layout of the petitioners. His further submission is that the roads also not being synchronized, the free flow of traffic is adversely affected. Shri Yogesh Naik is directed to place on record the rules applicable to a subsequent layout, rules applicable to formation of a subsequent layout while the neighboring land has an existing layout, an existing sanction layout, and how the roads and the drains and other common amenities, common public infrastructure needs to be aligned so as to provide better facilities for the residents of that area. And how in the present case a layout has been sanctioned without the roads and the drains being synchronized. The operation of order dated 7/10/2023 bearing number so and so at Annexure A and the sanctioned layout plan dated 7/10/2023 issued by fourth respondent Annexure B is stayed till the next date of hearing. Respondent number 3 is restrained from carrying out any layout formation works or otherwise till the next date of hearing. We list on 14. Process fee and copies to be furnished by end of day. Tomorrow, failing which the interim order will stand automatically vacated.
Only appreciated as the president for 8 months, not the 23, 11 to 8 months, he appreciated as the president. Now, what happens, local at the police, it may not the case under prevention of corruption act, that person to be known to some. In the first petition, we have placed the entire effort in the before the court, and kindly come to page number. Page number 17, That note, serial number 3. The counsel for the petitioner submits the petitioner will furnish all relevant documents pertaining to the source of income to establish the petitioner is not holding a. Such an application is filed by the petitioner in which he offers to consider the same. Matter is still pending. The invite I was to consider this. Notes in the meantime, what happens? 2 persons notes by Ramesh and Ramkrishna. They also give complaint notes to the chief executive officer to make certain allegations, and they filed a petition for this court. Annexure C, page 19. Now, this petition came to this court on 16/8/2023. But on that day, it was represented before the court that the inquiry is held and they have sought permission to initiate disciplinary proceedings against this petitioner. Lokaयुಕ್ta also communicates the chief executive officer to take action. But now kindly come to Annexure, at page 29. Letter written by chief executive officer to Lokaयुक्ta police. But in that note, page number 30. ಮಾಜಿ ಅಧ್ಯಕ್ಷರು ಆರಿ ಸದಸ್ಯರು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಯಲಹಂಕ ತಾಲೂಕು ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ ಅಧಿನಿಯಮ 1993 ಕಲಂ 43 ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸರ್ಕಾರಕ್ಕೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲಾಗಿರುತ್ತದೆ.
For disqualification.
There is no opportunity. Kindly see what is the allegation. Annexure F. This is the internal inquiry committee report against me. Annexure F at page number 31. Let us lordship come to page number 36. All pertaining to the allegations to the present incumbent.
Does the 43A require you to be heard?
Please not the mandate.
Where is it? Recommendation has been made.
But the recommendation is only after inquiry and submitting report, they should take a recommendation from the government.
This preliminary inquiry is done and they have recommended.
Typical
Now the government will have to issue you notice. They read 43A.
and straight away, there is judgment.
Read 43A first. Section nodi. I mean judgment to ban.
Government or an authority authorized by the government if it thinks fit on the recommendation by the Gram Panchayat.
Your recommendation agile. What you are showing us at page 30 is the recommendation.
It's a reference, there is a recommendation.
Hmm.
Or otherwise,
Hmm.
may remove any member after giving him an opportunity of being heard and after such inquiry as it deemed necessary.
So the government will give you an
But
opportunity.
and kindly see not the class 6 also. The former Objection or Upayaksha member of Gram Panchayat has been accused and proved guilty for misconduct or misappropriation in an inquiry.
That is one of the grounds.
In an inquiry.
That's a ground. Now there is a recommendation made. The government will issue a notice. You can reply to it.
Now, one more grievance is, there is only one allegation against me which does not also stand to test.
Either you can determine it, nor we can determine it. It's for the government to do it. Yes.
We give that allegations were made against Krishna as regard the financial irregularities in inquiry is also conducted to ascertain the unit. Based on the record, more particular bank statements of the Gram Panchayat states that petitioner is on the money in his name. Which is illegal. Also prove that report, not similarly, it's an inquiry report. Submitted by the Panchayat Development Officer, which discloses about financial irregularities submitted by the petitioner. But the question would be whether state government can hold a person incapable of performing duties of substance remains in.
There, what was challenged was the order of respond number 1, state government removing.
In this case also, there was no.
State government has not done it, Ms. Sarvana. You are premature. The state government will issue a notice, you reply.
But my case is the report itself, no, there is no.
Can we prejudge it now?
May I have this matter after litigation?
What is there after arguing for some time, you can't do that. Don't try doing all these things.
Because not this case is no personal hearing was provided to the petitioner, merely issuing the show cause notice and considering the reply would not.
That is by the state government under 43A.
Now what they will do is they will issue show cause notice and reply. The last paragraph, it is not dispute that no person was paid the petition. Merely issuing show cause notice and considering the reply will not suffice to take drastic penalty action.
You're prejudging it as to what they are going to do. They'll issue a notice and then they,
There are a lot of issues, not that unnecessary targeted.
that cannot be a ground here. And AGA accepts notice for respond number 1, Bangalore Zilla Panchayat. MS Devraj is directed to accept notice for respond number 3, 4, 5, 6, and 7. Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the recommendation has been made by the Gram Panchayat to by a sixth respondent to the third respondent for initiating proceedings under section 43 capital A of the Karnataka Gram Swaraj and Panchayat Raj Act 1993. The submission is that before such a recommendation was made, the petitioner has not been heard and no opportunity has been provided to the petitioner. And in this regard, he relies upon section 43, opposite capital, section 43 capital A. The submission is that without an opportunity being given to the petitioner, no such recommendation could be made. This submission would have to be tested on the anvil of section 43 capital A, which is reproduced hereunder for easy reference. The table of the above would indicate that the government or any authority authorized by the government, if it thinks fit, on the recommendation of Gram Panchayat or otherwise, may remove any member after giving him an opportunity of being heard and after such inquiry as it deems necessary. Such provision does not require an opportunity to be given before the recommendation, but only envisages that on the recommendation, if the government were to take it forward to issue a notice to such person, and thereafter, if necessary, conduct an inquiry. Hence, I am of the considered opinion that the above petition is premature. It is for the state to consider whether to issue a notice to the petitioner in terms of section 43A by accepting the recommendation or not. In the event of the state accepting the recommendation, then the state necessarily would have to issue a notice to the petitioner, providing the petitioner an opportunity to reply to the said notice. And if the state were to be state or an authority authorized by the state, be of the opinion that an inquiry is to be conducted, conduct such inquiry before initiating proceedings under 43A. The petition being premature is dismissed as such. Will unnecessarily lose an opportunity when
Review of advertisement fee. And I think my lord.
pass over. We are having that in the afternoon. There is a connected matter. When that is taken up, you remind us.
It was
51 in it.
Allowed.
51 allowed. 52, accepting the reason stated in IA 1 or 23 dispensed with ground rent annexure. Annexure A, connect with so and so. 53.
And Petitioner family, they own the agriculture land, about 1 acre in Veerapandra and everybody jurisdiction. Well, they have established a small scale industry, cottage industry, aroma industry, Davda. And also the family have built their constructions and houses right from 2000 on.
Notice ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ರೆ threat ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Threat ಮಾಡಿ everybody recently it has been coming to the jurisdiction.
Did AGA accept notice for respondent number 1 and 2? Everybody? So is like to accept notice for respondent number 3, issue notice to respondent number 4. Why have you made him in a personal capacity?
Mala?
Respondent number 4 at personal capacity. CMC councillor.
Councillor, accusation, all these things have, I made allegation also.
ಎಲ್ಲಾರ ಮೇಲೂ allegation. Notice to respondent number 4 returnable by 19th February. Respondent 1 to 3 are restrained from causing any demolition of the dwelling house of the petitioner situated in survey number 68/1 of Yav village, Veerasandra village, Ebugodi CMC, Anekal Taluk, Bangalore urban district till the next date of hearing. Process fee and copies to be furnished by end of day tomorrow, failing with the interim order will stand order. Yes.
It should be based on the Panchayat issued standing option notice for removal of the standing box grown by the petition. Petitions are.
We'll come back and take.
Yes.
Have you informed everybody? At the request of all the councils, relist on 5th February. ಅಷ್ಟೇ ಆಗಲ್ಲ ನೀವು ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ನಾವು ಡೇಟ್ ಕೊಡ್ತೀವಿ.
Serial number 74, my lord. Awarded by my lord's decision.
Wait, please, mentioning time alone. Yes.
No, Mr. Achappa wants time, 90.
Achappa is not here.
Number 55.
He is not asked for time.
I informed him.
Yes.
Serial number 55, my lord. Some inconvenience today, my lord, kindly have it.
55. Have you informed everybody?
Anytime after vacation, my lord.
The request of council for respondent number 6, relist on 5th February. 61. Yes. 5th February, 61, at the request of council for respondent number 2 and 3.
Regard to that one-time settlement.
56, learned council for respondent number 3 submit that there is a settlement. There is settlement under discussion.
Come back.
Settlement under discussion, given 3 weeks time. Further progress would be reported. Relist on 5th February.
We had a covering structure over the arch. We can demolish the structure over the arch wall. We had taken permission, they had decreed in our favor. Even thereafter, the meeting had come and demolished the property. On the property, my lords, the entire arch wall is open. It's not a situation. It's, we should notice in the matter. We should be in favor.
When is it?
It's, I think, for Monday.
A memo.
And
Monday.
Number 66, senior is not available. I have informed that.
Serial number
66.
66. The request to counsel for respond number 4. Relist on 12th February. Yes, madam.
The order has been complied with.
Why aren't you not appearing in all the matters? Nobody is appearing from Kalburgi yesterday. day
Due to some technical issues, we couldn't log in. Henceforth, we'll.
ಇವಾಗೆಲ್ಲ ಸರಿಯಾಗಿದೆಯಾ?
Now it is. We have to register.
You are not registered. Yes, where is the compliance affidavit?
On the last occasion, AJ has appeared and filed a memo, my lords, and that was not uploaded. The order dated 5/23 has not been uploaded.
There's nothing here. There's only one matter. Pass over. Pass over. Writ petition is allowed. The relief sought for by the petitioner are modulated. It is declared that the designation of the land of the petitioner of parks and green spaces, sports, playgrounds, cemeteries, burial ground, and revised master plan 2015 is deemed to have lapsed from midnight of 24/6/2012. The petitioners are at liberty to make an application in terms of subsection 3 of section 69 of the KTCP Act on the basis of surrounding development, which shall be considered and necessary orders passed thereon by respondent number 2 within a period of 180 days from the date of receipt of such application. Writ petitions are allowed in WP 442 so on and so on. So assertion is issued. The order dated 19/2/2013. Annexure A is quashed. Respondent is died. Consider the representation dated 27/2015. But Annexure P so on so within 4 weeks from today and calculate the service tax due on the amounts paid and payable by the respondent to the petitioner and release the said amounts to petitioner within a period of 4 weeks from date of receipt of a copy of this order. None appears for the petitioner, though called twice, once in the morning, once in the afternoon session. 4 weeks' time is granted to the petitioner to comply with author's objection, relist on 5th February. Get the copies?
They might say it exists. Line is flow, not be. Not as they claim. That's always between survey number. Private property.
Verify this, madam. Document ನೋಡೇ ಸರ್ವೆ ಮಾಡಿರ್ಬೇಕಲ್ಲ. No notice was required because the date was fixed by this court. You were to appear. Not on that date. But 23, it was directed to be carried out. Well, it has been carried out, madam, not on 2/12. The survey was carried out on 8/12.
Submit. There is page 30th. Is the layout plan.
The date was fixed as 2/12. You carried out the survey on 8/12. They were not there at that time. The date was fixed. They should have been done on that date and time, alwa. That is why we say no notice is required. 8/12 ಗೆ ಮತ್ತೆ notice ಕೊಟ್ಟಿದ್ರಾ? For them to be present. The Mazar is 8/12. Yes, page 30.
And which is next. Speaking of this layout is formed in 2 acres. Not a calculation, because page 29 is the conversion order.
ನಂಬರ್ 4ರಲ್ಲಿ 7 ಗುಂಟೆ ಮತ್ತು 38ರಲ್ಲಿ
135. What is this calculations made as per the instructions? Later it is instructed me to know what it is.
96,000 square feet ಅಂದ್ರೆ 2 ಎಕರೆ ಆಯ್ತು. 43,004.
6,170 square feet approximately. But apparently, the layout is formed in a larger area, which goes to, there is an encroachment. If my lord, I beg your pardon, my lord, I could not produce the memo. Lordship. Original survey, my lord. When the law is made out that proposed sheet law cannot be instituted. This is not inform and in the road and also canal, which is
Going through the-
and this canal not it touches the property and it touches the property of the petitioner alone. Now, my lord, this bridge is not at all touched to the petitioner's property at all. It is flowing through this property, which is encroached by the petitioner alone. Could we make out from this document?
Yes.
Three photographs. There is no lines. That lines will not be, this must be not, we are not accept properly. When you have that French is apparently it is coming on the under the class habit, and class habit goes there. What has to pass through? Because in the movie it continues to be main
It's flowing there.
entire layout itself is unauthorized or that is the instruction.
This is a layout plan sanction. This is the one.
That is from the ground from Soma.
Which year was this sanction? Was there a planning authority at that time?
Well, accordingly, may not, one may not, the topograph.
What extent? Which extent is it?
Thanks a lot. I've shown in my report, my lord. The extent of petitioner's side, my lord. The extent of encroached area is 891.
He has produced certain revenue documents which is
Showing that particular property goes. Where is the?
ಈ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಬೇರೆ ಲೊಕೇಶನ್ ಬೇರೆ ಕಡೆ ಇದೆ ಅಂತ ಇದ್ದಾರೆ ಅವರು.
Instruction. Can it fix the fence which is?
Submission.
The sketch that they have produced at page 5, the Tiffany, definition of that is a little different. Page 5 ನೋಡಿ, or ಇವಾಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ಮೆಮೊ ಜೊತೆ. Property dimensions and the shape looks the same. The location is a little different. Yes.
Can I call?
ಇದು ತೋರಿಸ್ಬಿಟ್ಟು ಹೇಳಿ. It's like going from the left to the right.
Road up there, new national highway came to the north. Okay, it is up.
Not concerned with the road, we are concerned with the nala.
That layout was report and survey was done.
And the revenue documents, this is a sketch. ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಮ್ಯಾಚ್ ಆಗ್ತಾ ಇಲ್ಲ. The face of it is not matching. They cannot shift alva. Documents which have been produced, unless those documents are wrong. But if you look at page 6 and page 7, page 5 and 6, 6 is a little enlarged version. In terms of your sketch, the nala is on the, it starts from the western edge. northwestern edge.
Where the survey number.
Your plan is by somebody who did not check all these. Should check if you are claiming a Rajkalvi or a Nala there. You can only claim through the revenue documents which are there, the Tiffany and Akarban which are there. So it is only this which can be superimposed on the survey. Not a layout. It's a layout as regards 15, 13, Adela, okay, that is our superimposition there. But the location of the Nala has to be as per this, unless it is shifted.
Maybe he is assistant. They are PWD. I can discuss with the.
ADLR. ADLR ಮಾಡಬೇಕು. Who has done this survey?
It's done by ADLR.
ಮತ್ತೆ ಅವರು ADLR has to superimpose the revenue documents, not the plan sanction. Or revenue documents along with plan sanction. It's not because another issue is they were not there when.
Not see, I can look into the day of that. This is okay. Yes, there are some illegal things.
It may be.
Yes.
We are only concerned with one side of the petitioner. Here.
That,
Alli Nala idyo ilvo. If it is in another site, you can take action. If it is not in the site of the petitioner, his submission is that it's not in his site, it's somewhere else and our ಹೇಳ್ತಾರೆ. ಅದು ಇವಾಗ ಚೇಂಜ್ ಮಾಡಿರೋದು ಅಂತ. You'll have to form it as.
I got it.
Everybody will form it wherever.
Then to take
Revenue department and take it as per this. That counsel for the petitioner has filed a memo enclosing certain revenue documents like the Tiffany, Akarban, secondary reclassification, the village map. Relying on the Tiffany and Akarban, he submits that the location shown by the ADLR in the survey report, it is different from the location as under the Tiffany and Akarban of the Nala. The submission is also that since the survey was carried out on 8/12/2023, though this court had fixed the date as 2/12/2023, he could not be present to place these documents before the ADLR and assist in a proper survey. In that view of the matter, the SCGP is directed to obtain instructions and make a submission as to the location of the Nala with reference to the revenue documents like the Tiffany and Akarban, as also as regards the actual present status of the Nala. Relist on
it's Friday.
Today is not a working day. Thursday,
Yes.
relist on 21st. Interim order earlier granted is extended to next.
Here it is. 71, 70. 73 is the. Okay.
73 is the petition stop.
73 is the petitioner's property.
Yes.
And it continues towards your Honor, 87 and 89. Right side. And number 87 and 89 are the disputed property now. The owners of the 87 and 89 are immediately next to my property.
Carry out is the next to it.
Assistance of ADLR.
ADLR will have. Okay. Pawan Kumar accepts notice for respond number. One to five. Sub-register ಏನಕ್ಕೆ ಮಾಡಿದ್ರು? Six will be the state. Officer sub-register appa, 6. The AG accepts notice for respond number 6, issue notice for respond number 7 to 13 returnable by February 2024. Respond number Director TDR, ಯಾರನ್ನ party ಮಾಡಿದ assistant director TDR ಏನಾಗಬೇಕು? You made assistant director TDR.
He is also giving exemption letters to register the property in lordship. That is under
Issue TDR certificates. That is not relevant. The respond number 4 and the jurisdiction ADTP are directed to cause a measurement of cause the inspection of the property bearing number 73. Kodiyalli Main Road, Woody Village, Madhevpura, Bangalore East. As also the property of respond number 7 to 13. Namely, property number 87/1, 89/1, 75/2, 92/6. Ascertain so and so. The inspection to be carried out commencing from 10:30 AM on 28th December 2023. The fourth respondent shall be entitled to obtain the services and guidance of the jurisdictional ADLR to carry out such survey and measure. Report to be filed on or before 24th January 2024. Released on 5th February. Event of writ being found that respond number 7 to 13 or anyone claiming under them are putting up constructions without a sanctioned plan or in violation of the sanctioned plan. The respond number 4 shall ensure that there is no further construction which takes place till the next date of hearing. Released on so and so. Process fee and copies to be furnished by end of day tomorrow, failing which the interim order will stand automatically vacated. Cannot abuse the process of the court in this. Tell him that. 46 relist on Tuesday.
Already had reached page 15. That is, functional association. Regard to the theme of office. Crops which are grown by the petitioners normals. Petitioners on the cultivation of the said land for more than 40.
Is that order in the coordinate bench you said you are permitted to harvest? See.
At page 21, para number 7, respondent that legal deputy committee are directed to identify alternative plans which are in the order of region. And any rate from the date of receipt of copy of this order, the petitioners shall be permitted to harvest the crops that are grown at present. And in this regard, the petitioners are permitted to remove the crops within a period of 4 weeks in the election. Even we had.
KLR matter.
Yes. Permitted to remove the. Alternative land is also not granted.
Madam, this is the order of 29 September 22.
Correct, my lords. Now they have issued this public auction notice stating that the three standing crops which are grown by the auction.
take the
Fixed crop. ನೀವು ಇನ್ನ ಬೇರೆ ಲ್ಯಾಂಡ್ ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ರು ಅಲ್ಲೇ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದಾರೆ. ನೀವು ಬೇರೆ ಲ್ಯಾಂಡ್ ಕೊಡಿ, ಅಲ್ಲಿ ಹೋಗ್ತಾರೆ. ನೀವು ಅದು ಕೊಡಲ್ಲ, ಇಲ್ಲೂ ಮಾಡಬಾರ್ದು ಅಂದ್ರೆ ಅವ್ರ ಜೀವನ ಹೆಂಗ್ ಮಾಡ್ಬೇಕು?
And farmers they have been cultivating for more than 40 years.
Whatever the land occupied by. For 6 months.
Develop the land, but you have to comply with para 7 before you develop the land.
Order clearly states that they have to remove the.
Eligibility alla illa. It's a positive direction to identify alternate land which is suitable for agriculture and grant it within 6 months. There is no further, there is a positive direction. Consider alive. Consider alive, positive. Because there is no pressure on you, you will continue doing it for 5 years now. Not only, it's on the same thing, it's on the same land. You give them alternate land and take this. But you can't throw them out without giving alternate land. Dispose ಮಾಡ್ಬಿಡೋಣ ಏನು? Dispose ಮಾಡಿದ್ರೆ alternate land ಕೊಡೋವರೆಗೂ look at it humanly. ಅವ್ರು ಕಷ್ಟಪಟ್ಟು ಎಲ್ಲ ಬೆಳೆಸ್ಬಿಟ್ಟು ಇವಾಗ ಅದನ್ನು ದುಡ್ಡು ತಗೊಂಡು ಹೋಗ್ಬೇಕು. You also were given. ಅದೆಲ್ಲ ಬೇಡ.
Responsibility to improve that feature of land.
Do that. Give them alternate land first. We'll stop the auction. And AG accepts notice for respondent number 1 and 2. Kunigal? A. Nagarajappa is director accept notice for respondent number 3. The auction notification dated auction notification at annexure B is stayed till the next date of hearing. When will you remove this crop? It must be ready for removal if they are auctioning.
Yes.
It is on 20th. It will be uploaded. It will be uploaded. Then AG is directed to inform the concern about the above instrument. Yes.
He comes.
Let him come. We'll pass over the matter. Pass over. After vacation.
Objections. Objections. Fix a date.
ಒಂದರಲ್ಲೇನೋ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂತ ಇದ್ದಾರೆ ಅದಕ್ಕೆ.
All the matters results in mind particular dates.
There is no interim order.
It moves an IA showing the change circumstances and also produce.
He'll be happy with the interim order. Disposal, they have to file their objection, Mr. Kumar. You can't do a disposal.
GST replace background and all. Except fees, that 50%
GST on ground rent you pay.
Yes, GST for advertising. GST for ground rent.
What is
And
it?
ground rent,
What is the GST you have paid for the advertisement?
18%.
On what?
On the display.
You collected the money from your service, you are the service provider. You gave a service to the advertiser. He paid you 1 lakh of rupees. Along with that 18% he paid. That 18% you have given it to the GST. That's a different transaction. So GST is not connected with this. GST on ground rent, yes, ground rent and GST. There's no other GST that you have paid on this transaction. The only issue is the advertisement tax has been amended and now advertisement fee coming in. Whether you are liable to pay advertisement fee now or not is what.
We have a right to answer that.
Oh, really? Let Mr. Holda come, then we'll take it.
Rate will be fixed.
You were in after vacation.
Vacation.
Haven't heard you like that too.
There is some protection.
Pure protection.
We want protection. What they do is. Stay there, they'll stay.
You agreed to pay the.
Next week.
Yes, Mr. Holda. Illa anta Ms. Sanjeev wanted to adjourn. Yes.
If you are not is completely not what is meant, whether the rules will apply. If you actually say not the
The prayers
Yes.
are for declaring 103 to be unconstitutional void. Advertisement bylaws 2006 to be unconstitutional void. The signage of 2018 to be unconstitutional void. The amendment of 20 now 1976 is no longer applicable to you.
not allowed, but D, A and D.
Prayer D.
We are told that the rate of tax of fee mentioned in Bangalore Mahanagarapalikka bylaws to show. Fee, outdoor signage and public messaging. It has to be PFP Act. So the sneaking provision will not be said.
Any proceedings initiated under the old act for it to continue under the new act. It is continued.
Therefore, will not they put it in this manner.
Section 6 of the General Clauses Act. Yes, please. For the interim order, your issue is whether the
Not the model. If you are not just saying not the bylaws itself.
bylaws of 2019.
Yes. Not 11.3. It's 24.
Yes.
The conditions, 11.3. The bylaw shall not apply to public-private partnership projects. Creating civic infrastructure like bus shelter, pedestrian walk, road medians, and such others by private parties using their own funds, in which advertisement facilities are given by the DPNC to defray the cost incurred.
To defray the cost.
But what happens is, the whole idea is
You are giving it, my lord, I mean, what they have to do, we are doing it. But it incurs, my lord, we have to maintain the expenses and we'll have to incur expenses.
Yes.
Therefore, my lord, the advertisement tax, my lord, needs to be, my lord,
For what period of time? Government. I think if you have spent for a bus shelter, you would have spent 5 lakh of rupees. So advertisement should be for how many years? It's only to defray the cost.
can I?
It will not be for,
Because we'll have to not continue to maintain, even if not it gets destroyed, we'll have to resurrect it. We'll have to clean it, we will have to not put the lights must be on. There's a maintenance continuously. If your lordship takes not my contract. If it is escalator, not all that, not lift, all that. Can I?
skywalks, road medians and such as that. Electricity would be for skywalks.
No, even
If it is
the
escalator.
shelters,
Hmm.
we must have not the lights there.
That is not given by the BBM.
No, everything has to be
There one is the part of the agreement, my lord, it's your sign.
You free ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಕಲೆ
ಅವರೇ ಮಾಡ್ಕೊ.
ಅವರೇ ಮಾಡಿ.
That is the terms of the, it's all right, I'm not, when people are not, I'm not saying that. I'm not to do it, I have to do it. That is the reason why, my lord, they say that.
All qualified by to defray the cost incurred. Yes, okay, let us keep it aside for now.
The contract itself.
Yes.
Please come to my lord, running pay. E&E, pay 186. Volume 2, my lord.
Sorry.
Payments into one, my lord, I must also bring this your lordship notice. What is against me? Please come to page 205. Last 19 years. Payment of advertisement tax shall also be paid up every year before the commencement of financial year within the first week of financial year. If your lordships come to my lord A, please have a look at A. The concessionaire would be required to pay to BBM a fixed annual concession fee of 44,100 per bus shelter per annum from the commercial offer till the end of the agreement. So every year my lord will have to pay this.
Yes.
Then concessionaire shall not be required to pay any concession fee for the public utility and information code. Only advertisement tax shall be payable for display of advertisement on the public utility and information of both sides. The annual concession fee payable to BBMP will include a 5% escalation per annum on the cumulative basis from the 4th year onwards from commercial operation date of the agreement until the end of the concession fee. Annual concession fee shall be paid after the start of the current financial years within the first week. Prevailing service tax will also be considered and payable over and above. When we pay the GST, what we are paying. Then payment of
GST would be on 44,100.
Yes.
That you have to pay. That is going to the,
Yes.
that is going to central kitty, not coming to the BBM.
Correct. Then, Lord, I will also be paying GST on Lord, the advertisement, Lord, the fee that I collect from the advertiser.
That's a transaction between you.
Correct.
That has nothing to do with BBMP
Yes.
again.
Nothing to do with the BBM. Then, Lord, this year, payment of advertisement tax will also be paid up every year before the commencement of the financial year within the first week of financial year. Any payment payable due from the BBMP shall be adjusted or set off by the concessionaire against the license fee payable by the BBMP. Then, Lord, insurance, I'll have to wait. Then,
Only issue from what we understood from what Mr. Ramesh made a mention last time is because if advertisement tax has got replaced by advertisement fee now.
now, my Lord, in that event, question is, then, Lord, BBMP bylaws, my Lord, will say
Yes.
that.
Will not apply to this.
Not clear.
But you agreed that advertisement tax would apply. And it is on that basis that this payment schedule has been.
Lord, then the question for your lordship would be, whether or not the statute would prevail or the contract would prevail.
Then the question would be whether the contract will go because of mistake of fact.
No,
Of both of you being under mistake.
there is no mistake. What happened is subsequent to this, please look at the date of this signature.
It is 2016 and second.
Subsequent to this, the legislature in its wisdom and the BBMP in its wisdom have decided that this is not payable. You look at it from that angle also.
The revenue to the BBMP, which is now, you have paid advertisement tax till now. Till now, you did not get affected by the advertisement tax being paid.
But if I paid by mistake, would that prevent me this?
This was payable as per your agreement that you have entered into. At that time, you did not say no to this.
No, please look at it. BBMP building bylaw, the advertisement bylaws, in 2019, you give me that consent. That is what I am trying to submit before your lordship.
That is only to defray the cost.
Then they have to compute. We'll have to, there are two things.
You will have to then place the record saying you have spent 10 lakh of rupees, 1 crore of rupees, 10 crore of rupees. This is how much I have recovered.
This is one way of looking at it. The other way, that or it will be, nothing is payable to you because you have to, defray the expenses. So you are giving you the full concession. Look at it from that angle. I know, I understand. It is question would be.
Sure, if we accept that we remembered after you made the submission yesterday, if we accept that, for example, you have spent 10 lakh of rupees on this bus shelter. We'll take the lowest one, we won't take the others.
I earn about 1 crore rupees or 50 lakhs of rupees.
You earn around 1 lakh of rupees or 2 lakh of rupees per advertisement per month. So you will earn around 24 lakhs per year for 10 lakh investment on this. The BBMP is getting 44,100 out of it. It will get deprived of the advertisement tax because of the tax going and the fee going. So BBMP will not have anything. You are going to get 24 lakhs on a public property for how many years? For eternity.
But please look at it from another angle.
And only some 5 lakh of rupees being your maintenance charge.
Look at it from this angle. EIDB will not allot land.
Yes.
In fact, I can tell you a lot. Rajkumar's house, in Sadashivanagar, opposite that, just three houses before that, there's a house of P. Krishna who was the advocate general. 18,000 he purchased it 100 by 120. Yes. Today the prices have gone up. Yes. Does it mean that they'll have to compensate the BBMP?
That is not the thing.
This is one aspect. Second is, please look at it from another angle. The BBMP is unable to get shelter. BBMP is unable to get advertisers because what happens is, it is because of my ability.
If this clause F was not there, we would have been in complete agreement with him. The problem is clause F was there and you have paid for the last 4 years.
I have. Demand was made for the first time in 2022, I believe. I'm not very much.
They're not paid advertisement tax.
I'm also. Are you sure? From 2017 till now, sorry, I stand by it.
Not paid, that's a different thing at all.
Yes, ma'am.
Now, please come to page 66.
If it is for the first time, my lord.
Yes. First time, yeah, page 66 is my.
Mr. Ramesh's submission, where is Mr. Ramesh?
2017 to, please come to page 66, annexure A1. First one. 6/9/2017 to 5/9/2018, next page. 18 to 19, 19 to 20, 20 to 21, 21. For the first time.
2022.
And this was issued in the year 2020, December 2020.
Remand has been made for 2017, now in 22.
Yes.
Both the years they have sent it now 22. Only
17.
17.
That is, they have sent it in 22.
How?
Then you can wait for some more.
The Lord is going to hear the matter on
The interim order will grant in this matter also.
subject to paying of the present fees they'll have to pay.
No, 44, whatever it is, not we will pay.
Should not happen that even the present,
Pay those
whatever
in advance.
44,000.
Either they will have to pay.
The
The question is this advertisement fee.
In the other matters, that is.
Mr. Sanjeev, you're, by your own this one, you are allowing them to loot the public property.
ಇಲ್ಲ ಅವರಿಗೆ look at it from this angle. They won't be able to get advertisement. They, after all, we know
They cannot do all the.
bus shelter ಮುಂಚೆ
Going for advertisement, going for the.
ಆ bus shelter ಅಲ್ಲಿ ಯಾರಾದ್ರೂ advertisement
ಅಲ್ಲ, ಇರೋ ಕೆಲ್ಸನೇ ಅವ್ರು ಸುಮಾರು.
Reasonableness in this. This is completely unreasonable. This is for the state to consider. This is, on the face of it, appears to be unreasonable.
This is, my lord, what they are doing is really too much, my lord. Now advertisement, if my senior counsel wants them to do, they may not do all that.
ಅದಕ್ಕೆ ನಮಗೆ ಕೊಡುತ್ತವ್ರೆ ಕೊಟ್ಬಿಟ್ಟು ಮತ್ತೆ ಬಲ್ಲಿ ಹೋಗ್ತಾರೆ. Industrialization KDB land ಕೊಡ್ತಾನೆ.
Lord, if the others have also stayed, my lord, I cannot say.
Say this also. ಬೇಡ, ನಾವೇನಾದ್ರು ಹೇಳೋದು ಕಷ್ಟ ಆಗುತ್ತೆ. We can't express our opinion, but only we can say petitioners have got a good deal in this. ಯಾವ್ದ್ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್? ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ? 1966 ಅಲ್ಲಿ ಇದೆಯಾ? The interim order passed in WP 1966 of 2023 shall inure to the benefit of all other petitioners in the present batch. Relist, Shri B.L. Sanjeev seeks fund is granted.
Matter of objections are there, I'll file it in the office.
Baki alla.
ಎಲ್ಲಾನು file ಮಾಡಿ.
Seeks fund is granted 4 weeks time to file a statement of objection. Objections returning to be filed on or before 31st January, relist on 6th February. 31st January, after serving a copy on the counsels for the petitioners, rejoinder, if any, to be filed on or before 15th February, relist on 22nd February.
But what we want to advance it, my lord, liberty may be granted.
In the event, liberty is reserved to the respondent corporation to move the matter for modification of the interim order, if any. 50 connect also same thing. Then. And delivery. So you will not come to your door to collect them. You'll have to look into this, Mr. From. Yes. Mr. Bandari's matter. Yes.
But my finally take the memo. That the nodal officer is online.
Mr. Mohanty,
So far as the NSAT is concerned, he wants just explain the chart which has been produced along with the.
the two members.
One is the affidavit. Other is the memo. Oh, summons.
Yes, Mr. Mohanty.
Lordship may see
Yes.
three things that we have suggested for the e-summons, that is the end step and virtual courts. And then the remaining things that we have put in the affidavit. Most of the things have been complied with, Lordship. And one thing that is left out is the end step. Where we are suggesting a model that is in phase Roman 3 of the annexure.
Yes.
So there are three things. One is the current process flow of end step as adopted by the Honorable High Court. The second one is the current pilot that is running for Malleswaram Police Station for 6 courts which have been identified. And the third one is the one that we have suggested. The first step is current process flow of end step is already smooth and functioning. So that needs to be amplified to use the service of criminal processes as well, and also close the last mile.
Yes.
So for that, the current pilot was arranged for Malleswaram Police Station using NSTEP, in which summons other than civil processes will be served.
Yes.
So here, Lordship may see the process flow. The step one is from the CIS database, which is publishing the summons onto the NJDG. NJDG is actually the National Judicial Database. That's another database, transitional. That in turn pushes it to the NSTEP web portal. This is an established process. This is already functioning. In the web portal, the admin creates a PS process staff. It gives a user ID to the process staff and then pushes the process to that staff who has been created. So this is part of the established process. Then that goes to the NSTEP mobile app, which is housed on the personal device assistant, digital assistant of the process staff, or a mobile phone. So now here it has been pivoted during the pilot to step number 5, which is going to the process staff at Malleswaram Police Station. The Malleswaram Police Station, I'm sorry.
Yes, go ahead.
So here it is going at number 6 to the process execution with photo and geolocation, which is supposed to be captured in app, and then it is supposed to get uploaded, which this process is not yet complete. So it is still getting done manually. So we received actually input from the Honorable Registrar Computers, to wherein they have pointed out that summons allocated manually to the Police Commissioner's office are not getting reflected in the NSTEP mobile app for further service. So this is the problem between steps in phase 2. Steps 5 and 6, which we are trying to resolve. But then this in itself is creating certain problems for the police IT administration. So which we have also mentioned in the main affidavit, if Lordship may see paragraph number 6, 5 and 6, the main affidavit. So in para number 6, we've asked for an admin access in the NSTEP application. The information on service of summons can be automatically populated in the police IT CCTNS software, and manual feeding of information will no longer be required. What's happening now is we are asking the service constables or the service staff to enter it manually once the summons is issued by the court. And once that happens, then the process is to push that summons for service. And once the service is done manually, again, it's manually updated onto police IT software. So now that is a very cumbersome process. If we could have a visibility into the NSTEP mechanism, as has been shown in page number 2, somewhere between steps 5 and 6, instead of going to Malleswaram Police Station, which has been directly allocated the summons service by the portal in the court, if it comes to police IT, we can do that job for them. In the process, we can also update our own proceedings, and we can have a full end-to-end visibility of the criminal process service instead of waiting for the manual service to happen. Alternatively, we have suggested phase 3, Lordship can take a look. It's a little more complicated. This is an end-to-end process that we have suggested. So here the CIS is publishing the summons and pushing it to the NJDG, which in turn pushes it to the ICJS. Now, there are 2 APIs already existing in NAPEX. NAPEX is a national API exchange that we are having. It's an open API platform. which is summons metadata API, basically data regarding the summons, date, issued, case number, etc., not the physical summons itself, copy of the summons. And B is the summons PDF copy, which is individualized. Each summons has a PDF copy. So then, as a number 4, what we are planning to do is we will perform a batch processing service using metadata API once every 24 hours. That will pull the summons which are pending out of the ICJS and the judicial platform into police IT. So we will know which summons are pending at the end of the day. That again pushes it back to the ICJS to get the physical copies of the summons as step 5 and step 6. So once ICJS gets the request from our police IT or CCTNS, that particular batch process gets generated, and we also get the information at step 7 regarding the PDF. We also get the PDF downloads. And then after the download happens, process number 10, after the police IT, if Lordship looks at it, we are proposing a process mobile API, not APP, mobile app come API by the PCW. So what that is going to do is, it is going to put that physical copy of the summons which we have received in police IT into that mobile format. As step 11, that particular app is going to post the process information for service execution to the police station process staff PDAs. That app will push it to the app on the, which is existing corresponding app on the client app on the servers, the process service app. Thereafter, the process execution happens. Photo and geolocations are captured in app. So whatever that person does with the camera will be captured in app, and he cannot do it independently. And as soon as it is captured, it will get updated automatically onto the police IT or the CCTNS platform at step 13. And finally, after all these processes are complete, we will be designing another API to push the information that we have received onto the ICJS and then the CIS.
The fulcrum will be ICJS in this.
Yes, Lordship. So we are integrating NSTEP into the ICJS.
And for page 2, you need admin access.
Page 2, we need admin access. So that can be an intermediate step before we implement page number 3, the flow chart at page 3. So here, whatever is happening in the NSTEP mobile app at step number 4, instead of going to process staff at Malleswaram PS, should come to police IT, CCTNS. From there, we will push it to the concerned police station. Currently, it is only one police station, but in the future, we may plan to make it all the 1,000 police stations across Karnataka.
The police constable himself register as a bailiff in this app?
That's correct. We'll be giving user IDs and passwords for each of the bailiffs come process service.
So yeah, admin is for what purpose?
Admin is for overall visibility, because we have to update the summons process in police IT also. Otherwise, that has to be done manually after the process is complete.
The dashboard that you require.
Yes, Lordship. And downloadable data. So once the process is
downloadable with exportable, downloadable data.
Correct, Lordship. So we can auto-populate police IT platform. So we wanted this process to happen at step number 5 through police IT, instead of happening at the individual police station levels, because that is going to cost us visibility in terms of automation.
Yes. Maybe page 3 may not happen right now, but page 2 we can look.
We will maybe get on top of this, because it's entirely in our hands. We're not depending on NIC for this. Phase 3. We'll do it after.
Let me go through this a little more in detail.
Yes, Lordship. The second thing, Lordship, is regarding the virtual courts. This is para number 7 and 8.
So feasibility study is being undertaken.
We have already done the feasibility study, Lordship. So here, Lordship, we might point out that there is already a traffic violation management system existing in Bangalore, which is connected to the only existing virtual court. That's for fines. People generally will be paying the fines. Another one on similar lines is happening for the remaining parts of the state through an organization called CTRS, that is Commissioner for Road and Traffic Safety. There's another ADG who deals with this. So they are also planning to go along Bangalore lines for another pipeline into the virtual court.
They have to be integrated.
That is only for traffic offences, Lordship. But then we are planning to have a lateral expansion into NI processes as well, into criminal processes where the acts are minor, KP Act and other minor acts, special local laws where compounding of offences are possible and just fining is possible. For that, this particular model might be a cumbersome model. Why that should be so is that we'll have to build another pipeline and another database which will feed in NI Act and for criminal processes into the virtual courts. Instead of that, a simpler model would be to combine all three, the existing Bangalore platform, the proposed CTRS platform, and the proposed other offences platform from Police IT into one single database and then push an API into the virtual court system, depending on how many virtual courts there are planned to be. This becomes a convergent solution and an easier solution for us to implement and execute.
So you're working on a project report for that?
We have already submitted a single page this thing. So once the court, we wanted the courts to learn the court's guidance on this, whether it should be 3 pipelines or just 1, 2 for traffic and 1 for other offences, or shall we go in for a single pipeline?
Yes, that we'll look into on the administrative side.
Yes, Lord. And remaining everything has gone on, Lordship. We have already complied with everything else. ICJS is going on apace.
Now, EDAR,
we have received actually a particular set of this thing. Do you have that EDAR thing? EDAR is also, Lordship, we have done a lot of work on EDAR. But in the integrability platform, anything else? All the Lordship may take a look at para number 9.
the training.
So training is already complete. We have identified the district informatic officers and the DROMs who are going to implement DR in the district. So we've identified all the stakeholders. We have already asked these people to obtain e-sign particulars for themselves and for their supervisory officers so that the process can begin. But the EDAR platform itself is under development with NIC, and that needs to be expedited, Lordship. The remaining peripheral developments, what we are supposed to be doing to implement EDAR is already complete. Once EDAR is executed or it's put on a beta platform, we will be able to execute it instantaneously. So a set of instructions to NIC will be in order, Lordship.
Bit of it. Affidavit along with documents. An affidavit of the Additional Director General of Police, Police Computer Wing, along with documents has been filed. Where it is indicated that a proposal as regards integration of the traffic virtual court system, CTRS, traffic violation management system with virtual court database has been submitted. In respect of EDAR, it is stated that the train the trainer program has been conducted. And once NIC were to implement the EDAR system, it could be integrated with the ICJS and the court system. The submission is taken on record. A memo enclosing the proposed summons execution model has also been filed, indicating the current process flow and the proposed current process flow, current pilot, and the proposed process of execution. The same is taken on record. To report further compliance, placed on 22nd January 24. Thank you, Ms. Mohanty.
Awesome. Leave.
ಎಲ್ಲ ಆಯ್ತಾ ಇವಾಗ ಪೇಪರ್ಸ್ ಎಲ್ಲ ಬಂತಾ? ಅವ್ರು ಬರ್ಬೇಕು. ಎಲ್ಲ ಆಯ್ತು, ಇದೊಂದು ಉಳಿತು. Adjourning this matter for one reason or the other. The request of the additional SPP released on Monday. Tuesday. Wednesday. ಯಾವತ್ತು ಹೇಳಿ? Wednesday. Wednesday 2/3. R1 R2 ಮಾಡ್ಬೇಕು. ಅವ್ರಿಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಟೈಮ್ ಕೊಟ್ರೆ ಇನ್ನ ಫೈಲ್ ಮಾಡಿದ್ರು. That also for respondent number 3 has filed its statement of objection. The same is taken on record. That SCGB seeks for request for the matter to be taken up on 18th for filing its objection and addressing arguments. Released on 18th. 2/3. For the adjournment to be granted and carried. Unwell and rain madakagalla. At the request of counsel for respondent number 1, 2, Gangadharappa. Just on 18th. This one, 18/12 at 2:30 p.m.
Conclude the hearing, my lord. So we have to file an affidavit, sir. Direct municipal administration had to file an affidavit on what action will take against the CMC for issuing the plan. It is on 21st of September.
The request to learn AG released on 21st. Let him file it. We know your senior's marriage is going on. 21st. The Naveen Sadashivaya. The urgency, Mr. Patil?
Because now the sketch is produced by the municipality 26/9.
Yes.
Floor. By sheet roofing, the floor is covered. It's sought to be rented out for a bar and restaurant.
Mr. Naveen. ಬಂದಿದಾರ ಬೆಳಗಿನ ನೋಡಿಲ್ಲ.
Dispatch was here.
Now that this has come about, they have to issue notices.
They are already, notice also was issued, but municipality has not taken any action.
Not taken any.
So from the 2/2023, they issued the notice.
Yes.
They are stated so in the application statement also.
Told. The memo dated 26/9/23 has been filed, enclosing a sketch showing the deviations in the construction in terms of setback as also the area of construction. If that be so, the respondents cannot issue any trade license or the like for usage of the property which has been, usage of the constructed area which has been so constructed in violation of the plan sanction and or the building bylaws. As such, the respondent number 1 is directed not to issue any trade license as regards the area which is in violation of the plan sanction. Released on 7th February. Cannot issue ಅಂತ ಅದಕ್ಕೆ ಹೇಳಿದೆ as regards the violated area. Non-violated area, they can get the trade license. Your contention is only 3rd floor.
Like it is up to 9th, 12th.
Yeah.
That was.
Yes. Madam, who is appearing? Manu Prakash or Rini? Manu Prakash. Ashok. Like 108, ನಿಮ್ಮ ಇದ್ರಲ್ಲಿ ಬರೀ ಓನರೇ ಇದೆ.
Sum of 6,500 towards the per acre is original owner. The context when the property has been let to any shop owner, trade license has to be obtained by the occupier who is conducting the business. In the context we have raised it since 2 years they are carrying on the structures and they are carrying on the.
Then cancel the trade license because the property tax has not been paid. You can't ask them to pay the property tax. Property tax, trade license cancel ಮಾಡಿ. There is no property tax, so this. ಏನು trade license ತಗೊಂಡಿಲ್ವಾ? Trade license ತಗೊಂಡಿಲ್ವಾ? Michelle?
Page number.
Have you taken a trade license or not?
Such I have not taken, but I have only put the, I'm not doing anything. Construction, only the materials are placed in the.
Are carrying on work as per your own Annexure F series. Annexure F series, you are carrying on work in the property.
Page 24.
You don't want to pay the tax also, you don't want trade license also, then.
Permission is provided.
I'll get instruction from this, but I'm not carrying out any. That I have.
Then we'll remove your cranes from there. Where you are doing where you are using the molds for the purpose of creating the RCC, precast RCC. Using your RCC ready mix plant. You have a ready mix plant, you got a assembly line, and you got a storage yard.
That I have kept for the construction project.
ಮೂರು ಇದೆಯಪ್ಪ.
I'll take instruction on the trade license.
You are doing the precast RCC there. You are not just storing it.
I'll come back next week.
Or we'll record that you're not carrying any this one, then they'll stop you.
Them edited before that.
Monday. That
But will be in progress on the plan. Without obstructing them for 2 years, they have made allegations. But page number 79 ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಸರ್ಜಾಪುರ ನಗರ ನೈರಿಗಾ ಗ್ರಾಮ ಪಂಚಾಯತಿಯ ಕಿಚ್ಚಂದ್ರ ಗ್ರಾಮದ ಕಂದಾಯ ಜಮೀನಿನಲ್ಲಿ
page number
79 ಕಾಮಗಾರಿ ಸಾಮಗ್ರಿಗಳನ್ನು ಉತ್ಪಾದನೆ ಮತ್ತು ಶೇಖರಣೆ ಮಾಡುತ್ತಿದ್ದು ನೀವು ಸದರಿ ಕಾರ್ಯವನ್ನು ಮಾಡಲು ಗ್ರಾಮ ಪಂಚಾಯತಿಯಿಂದ ಯಾವುದೇ ಅನುಮತಿ ಪಡೆದಿರುವುದಿಲ್ಲ. ಮುಂದುವರೆದು ಭಾರಿ ತೂಕದ ವಾಹನಗಳು ಈ ಮಾರ್ಗದಲ್ಲಿ ಸಂಚರಿಸುವುದರಿಂದ ರಸ್ತೆಗಳು ಹಾಳಾಗುತ್ತಿದ್ದು ಸಾರ್ವಜನಿಕರಿಗೆ ಅನಾನುಕೂಲ ಉಂಟಾಗುತ್ತಿರುವ ಬಗ್ಗೆ ದೂರು ಕೇಳಿ ಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಕೂಡಲೇ ಸದರಿ ಕಾಮಗಾರಿಯನ್ನು ನಿಲ್ಲಿಸುವಂತೆ
ಉತ್ಪಾದನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಇನ್ನೊಂದು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಮೇಲೆ page number 8.
Photographs ನೋಡೋಣ ಗೊತ್ತಾಯ್ತು. They are doing the precast and storing there. There is RMC plant also. Otherwise you don't need RMC plant. ಕಾಣಿಸ್ತಾ ಇದೆಯಾ ಫೋಟೋಗ್ರಾಫ್ ಅಲ್ಲಿ RMC plant.
ಎಲ್ಲ ಮಾಡೇ ಮಾಡ್ತಾರೆ.
Page 76 ಅಲ್ಲಿ ನೋಡಿ ನಿಮ್ಮ RMC plant ಕಾಣಿಸ್ತಾ ಇದೆ. ಸ್ಟೀಲು ಎಲ್ಲ ಇದೆ, ಕಾಂಕ್ರೀಟ್ ಇದೆ. ಮಾಡಿಬಿಟ್ಟು page 77 ಅಲ್ಲಿ you are storing it there, which will be transported to the work site and used. Then it counsel for respondent number 2, Shri M. Pradeep and counsel for respondent number 2 submit that the petitioners are carrying on business in the subject premises without obtaining trade license, in as much as they are manufacturing precast items to be used in metro work. Learned counsel for the petitioner without obtaining a trade license. Learned counsel for the petitioner seeks for and is granted 2 days time to obtain instruction, make a submit. Learned counsel for the petitioner request for the matter to be taken up on 18th, released on 18th at 2:30. 19th.
Page number 46. Yes. Police standing right next to a blue door. Blue door. This is the 3 feet by 43 feet, which is a dispute. This, in fact, the police has issued a notice stating that produce document report in respect of this 3 feet by 43 feet. The BBMP at Annexure A issues a notice under 313. The assistant executive engineer issues a notice under section 313. Calling upon me to produce documents in respect of the property that I own. They don't specify. There are 2 properties. There are 2 pieces of land which have been purchased separately. One 3 by 43, the other one being 25 by 40. Both these sale deeds are available in that. Now they don't specify which documents to be produced. I, however, produced the documents for both these portions of the property. All of a sudden, 11/12/2023 is the notice issued. 14/12 yesterday at about 10:30 or 11 o'clock.
Did you reply to Annexure A?
Yes, please not, but Annexure D, Lord will find it at page number 45. Even all the documents which are in my power and possession. There's an acknowledgement also at the bottom of it.
Yes.
And thereafter, Lord may kindly see at Annexure A and 46, 47, 46, the second photograph that I produced Lords. There's a BBMP van, there's a BBMP worker who is with a crowbar ready to demolish the property. There are about 15-20 people who come up. There's no order passed, there's no inquiry made. And this 313 notice is issued by an assistant executive engineer who has no.
3 notice, how can you demolish?
He has no locus to issue.
I actually believe that the public to be specific is naming earlier it was open. Because they were using, only way which connects to the main road.
Otherwise, they have to move around for 1 kilometer to public complaint.
The private land, public cannot ask for it if they have to go for 2 kilometers.
That cannot
Just a moment, please. You should know when you should talk, when not.
Given the notice is issued, you get the document. Yes. These photographs are taken when they have reached to the spot to measure the property. They are given the two sailors. Whether it is a private, if it is a private property, obviously, you know,
So you're not going to demolish.
measurement.
The annexure key.
You're recording a statement that is not demolition. What else do you want?
So far as point number 2 is.
And we should record that he is going to demolish. Yeah, no problem.
Proceedings. Now we have taken the measurement. Further action will be.
Three. Pawan Kumar accepts notice for respond number 1 and 3. Then AGA accepts notice for respond number 3 and 4. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that on a issuance of a notice under section 313 of the BBMP Act 2020 dated 11/12/2023, though the petitioner has replied to the same and furnished the necessary documents, there is an apprehension that respondents will demolish a property belonging to the petitioner. Pawan Kumar, learned counsel for respondent 1 and 3, on instruction submit that there is no such demolition activities contemplated. The notice under section 313 was issued to ascertain the ownership of the property in question, passage in question, since there were complaints by the neighboring neighbors saying that an access to the main road had been closed. The documents submitted by the petitioner would be examined, verified if the said property is under the ownership of the petitioner, and only thereafter necessary steps would be taken. But after issuing notice to the petitioner, his submission answers the grievance of the petitioner, placing the submission of Shri Pawan Kumar, the counsel for the corporation, the petition stands disposed.
Police have also indicated property. They have issued a notice calling upon me to produce the documents.
That means- Page
16.
16.
ಈ ಮೂಲಕ ನಿಮಗೆ ತಿಳಿದುಕೊಡುತ್ತಿದ್ದೇವೆ ಎಂದರೆ ಮೇಲ್ಕಂಡ ವಿಳಾಸ ಓಡಾಡಲು 3 ಅಡಿ ಜಾಗವನ್ನು ಸಾರ್ವಜನಿಕರು 20 ವರ್ಷಗಳಿಂದ ಜಾಗವನ್ನು ಓಡಾಡುತ್ತಿದ್ದ 3 ಅಡಿ ಜಾಗವನ್ನು ಓಡಾಟ ಕೂಡ ಮಾಡಿಕೊಂಡು ಸಾರ್ವಜನಿಕರು ದೂರಿಸುತ್ತಾರೆ. ಸದರಿ ದೂರಿಗೆ ಪ್ರಕರಣ ದಾಖಲಾಗಿದ್ದು ಪ್ರಕರಣ ವಿಚಾರಣೆಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಸದರಿ ಜಾಗಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲಾತಿಗಳನ್ನು ದಿನಾಂಕ 14/12.
That's a complaint filed, they will inquire. Insofar as the complaint registered by the
notice issued, court email is expected to produce these documents.
By the respondent number 2, petitioner is granted a week's time to produce all the necessary documents for respondent number 2 to carry out the necessary investigation, if any. Needless to say, if the investigation requires civil disputes, the jurisdiction police would not be entitled to carry out any investigation. Anyway, mad read.
Because I had appeared in the earlier round. There's a clear that.
Then we'll have it on Tuesday and hear both together.
Same day. Today is end of today. Tuesday, we might argue to. Tuesday, not. On petition, there is no notice. Blacklisting in respect of better. Made applicable to another company. I am not been. There is no show cause.
No show cause.
No notice. No allegation against.
No show cause notice. Without a show cause notice, you can't blacklist.
I have a difficulty in this. I had appeared in the earlier round to create that instance. It will match your paper. That's the reason.
want to make any.
But you'll have to place on record the submission.
Side effect, right?
Yeah,
And
file
in the
this with-
objection, they admit blacklisting is not applicable to this petition.
But ಇನ್ನೇನಂತೆ?
He'll answer yours. Use them.
They've admitted, you should withdraw the petition.
In paragraph 9, they say in the counter, blacklisting order in respect of a element is not applicable to the petition. The executive engineer said, in view of that blacklisting order, I will also blacklist.
Instead of this matter being pending, you just issue a notice, that's all. Anyway, list on Tuesday at 2:30 p.m. Yes, Mr. Basaraj. What inspection report ಆಗಿದೆ?
File ಮಾಡಿ. They are not in file.
And appears for the petitioner released on 12th February.
Yes, Venkateswara.
Service.
Three 3 actually sounds so hard. Let me go into it. We need to.
Thank you. Manjunath. Manjunath. Address ಬೇರೆ ಇದೆ. This 4 3rd E cross 26 BTM layout ಇದು. ರಾಮನಗರ. This is appointment. ಮಂಜುನಾಥ್ ಅಡ್ರೆಸ್ ಆಗಿದೆ.
From the affidavit submitted before this order. Fine, my lord, there is something. Some variation in this.
Sent to the forensic lab. FSL occurred, sir.
That apart of the original copy is compared.
What happened in KD? KD dismissed the matter.
This.
We should take back the return.
This is the.
On 16 in the litnik ಇದೆ.
What has happened in the OS case to the complainant in that they have compromised. It is related. But not somebody else.
308 ಇದೆ.
ಅಲ್ಲ ಮಂಜುನಾಥ್ ಅಂತ ಅಲ್ಲಿ ಯಾರೋ ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ.
We are concerned with 321.
But here it says Manjunath, only will not. Chances that some could have.
Only way we can ascertain is by sending it to FSL.
I understand. I will not found the affidavit to ಅಲ್ಲಿ variation.
Signature ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ will accept you. Signature ಇದ್ದು ನಂದಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಕಳಿಸ್ಬೇಕು. ಆಮೇಲೆ then we'll have to see against whom. The statement correct, your statement. If they have fudged somebody's signature, we'll have to take action.
Suppressed loss percent defendant, that's a different issue. Otherwise,
Check with him before we refer. Pawan Kumar learned.
otherwise it could place original record so that.
We ಹೇಳ್ತೀವಿ.
Please.
Verify from him whether it.
I
Pawan Kumar produces the original file. However, we submit that insofar as the aspect relating to service are concerned, those documents were produced before the KAT and are at present in the and continue to be in the custody of the KAT. He seeks for and is granted 3 weeks' time to secure the said documents and secure the original and produce them. He however submit that in the photocopies which are found on the file, there is a signature of the petitioner found. And as such, the service under section 320, the service of notice under section 321 has been effected on the petitioner. The counsel for the petitioner seeks for and is granted 2 weeks' time to obtain instruction and make his submission. In the event of there being a denial of the said signature, the matter would have to be referred to the forensic science laboratory to ascertain the veracity of the submissions made either by the petitioner and the counsel for counsel for the corporation. Read this now. ಅಲ್ಲಿಂದ ಆ ಥರದ 3-4 ವಾರ ಆಗತ್ತಾ? List on 2nd February. Not here. Here but not here. ಯಾರು ಬರ್ಲಿಲ್ಲ. 58. ಏನು ಹೇಳಿಲ್ಲ ಅನ್ಸುತ್ತೆ ಸಜ್ಜನ್. But in person, what a GPA holder. The petitioner a party in person or represented by a counsel? Chennai Gowda GPA holder and take across the street. Represented by counsel. Gowda ಏನದು? Appears for the petitioner today. Relist on 12th February. If none were to appear for the petition on that date, petitioner will be liable to dismiss the number. It's a little. And appears for the petition dismissal antiday. Despite the order dated 29/11/2023, none appears for the petition today also. It appears that the petitioner is not interested in prosecuting the matter. Petition stand dismissed for non-prosecution. 14%. चलो ಯಾಕೆ ಫೈಲ್ ಮಾಡಿರ್ಬೇಕಲ್ಲ workable. This is direct print the name of so and so as that appearing of the petitioner. Released on 20th February. If I appears for the petitioner today, released on 20th February. Appears released on 20th February. Request of counsel for the petitioner released on 20th February.
Yes, Channagamai. So I wanted it. They filed the worker, they filed objection. You follow. Next time.
Yes.
Channagamai.
Channagangaya has filed Wakaratnama for respond number 2 and 4. Registry is directed to print his name as such.
But
Huh?
2 and 4, 2 and 3.
Last time. 2 and 3 ನೀವು appear ಆಗ್ತದೆ 4 Channagangaya. ಅದಕ್ಕೆ ಅವ್ರು ಫೋನ್ ಮಾಡಿದಾರಂತೆ
ಗೊತ್ತಾಗಿಲ್ಲ
ಹೆಸರಿಲ್ಲ ಅಂತ ಇವತ್ತು it is submitted that Shri G.H. Channagangaya continues to be on the panel of respond number 4. As such, registry is like print his name as that appearing for respond number 4 and print the name of Shri B.J. Somiyaji as that appearing for respond number 2 and 3. Released on 20th February.
Not the Paura Karmika Sunny lawsuit. Under the scheme, my lord, the petitioner was permitted to carry out, my lord, build, operate and transfer.
Yesterday, somebody mentioned for adjournment.
Should I inform the senior immediately that all could not be expected in.
All could not go through is not information.
Should we apologize?
ಮಾಡಬೇಕು ಅವರು ಅಂತ ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು ಇಲ್ಲಾದ್ರೆ ನಿಮ್ಮನ್ನ ಬಿಡ್ತಾ ಇರ್ಲಿಲ್ಲ.
That's why whenever time is needed, evening itself you can call. ಇಲ್ಲಿ ಕಾಲ್ ಸಿಗೋಲ್ಲ ಇಲ್ಲಿ ಯಾರಿಗೂ ಸಿಗೋಲ್ಲ ಇಲ್ಲಿ ಕ್ಯಾಮರಾ ಹಾಕಿದ್ರಿಂದ
ಫೈಲು ತಗೊಂಡ್ ಬರೋದ್ ಬೇಕಾಗಿಲ್ಲ.
ಅಲ್ಲ ಹಂಗೇನಿಲ್ಲ, ಹಂಗಂದ್ರೆ ಫೈಲ್ ಅಂತೂ ಬಂದೇ ಬರುತ್ತೆ. ಬಟ್ ಫಾರ್ ಎನಿ ರೀಸನ್ ಇಟ್ ರಿಪೋರ್ಟ್ ಡು ನಾಟ್ ಪರ್ಮಿಟ್ ದೆಮ್ ಟು ಇದು
ಹೇಳಿ ಏನು
ಕಾರ್ಯಾದೇಶ ಮೈ ನಾಟ್ ಮೇಕ್ ಎನಿ ಸಿಮ್ ಪೇಜ್ annexure B2 page 21 ವಾಟ್ಸ್ ಇನ್ ಕೇಸ್ ನಾನು 119 ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ
ಪೇಜ್ ನಂಬರ್
page 21 B2
B2. Yes.
This is the work order, my lord, which is issued to the son of the Pora Karnataka. There is a scheme, my lord, ಇದೆಲ್ಲ ಮೇಂಟೆನೆನ್ಸ್ ಇದೆಲ್ಲ ಅವರಿಗೆ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ ಸ್ಕೀಮ್ ಮಾಡಿದ್ದಾರೆ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ವಾರ್ಡ್ ಸಂಖ್ಯೆ 119 ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ SJ ಪಾರ್ಕ್ ರಸ್ತೆ ಟೆಂಪೋ ನಿಲ್ದಾಣ ಎದುರು ಸಾರ್ವಜನಿಕ ಶೌಚಾಲಯವನ್ನು BOT ಬಿಲ್ಟ್ ಆಪರೇಟ್ ಅಂಡ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅಂಡರ್ ನಮ್ಮ ಬೆಂಗಳೂರು ನಮ್ಮ ಕೊಡುಗೆ ಮಾದರಿಯಲ್ಲಿ ಪಾವತಿಸಿ ಉಪಯೋಗಿಸಿ ಮಾದರಿಯ ಶೌಚಾಲಯವನ್ನು ನವೀಕರಿಸಿ ನಿರ್ವಹಣೆ ಮಾಡುವಂತೆ ಉಲ್ಲೇಖ ರೀತಿ ಜಂಟಿ ಆಯುಕ್ತರಿಂದ 14/12/2018 MOU ನೀಡಲಾಗುತ್ತದೆ. ಮೆಮೊರಾಂಡಮ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ವಾಸ್ ಎಂಟರ್ಡ್ ಇಂಟು. ಅದರಂತೆ ಸಕ್ಷಮ ಪ್ರಾಧಿಕಾರದ ಅನುಮೋದನೆಯನ್ನು ಪಡೆಯಲಾಗಿದ್ದು ನೀವು ಈ ಕೂಡಲೇ ದಿನಾಂಕದಿಂದ ಸಾರ್ವಜನಿಕ ಶೌಚಾಲಯವನ್ನು ನಿರ್ಮಾಣ ಮಾಡಲು ಅಥವಾ ಪ್ರತಿ 5 ವರ್ಷಗಳಿಗೊಮ್ಮೆ ಕರಾರನ್ನು ನವೀಕರಿಸಿ ಒಟ್ಟು 10 ವರ್ಷಗಳ ಕಾಲಮಿತಿಯಲ್ಲಿ ಶೌಚಾಲಯದ ನಿರ್ವಹಣೆಯನ್ನು ದಿನಾಂಕ 4/1/2019 ಮಾಡಿಕೊಂಡಿರುವ ಕರಾರಿನಂತೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂಡ್ ಮೇಂಟೆನೆನ್ಸ್ ಆಫ್ ವೇ ಅಂಡ್ ಯೂಸ್ ಪಬ್ಲಿಕ್ ಟಾಯ್ಲೆಟ್ ಅಟ್ SJ ಪಾರ್ಕ್ ಟೆಂಪೋ ಸ್ಟ್ಯಾಂಡ್ ಆಪೋಸಿಟ್ ಇನ್ ವಾರ್ಡ್ ನಂಬರ್ 119 ಶೌಚಾಲಯ ನಿರ್ಮಾಣವನ್ನು BOT ಬಿಲ್ಟ್ ಆಪರೇಟ್ ಅಂಡ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅಂಡರ್ ನಮ್ಮ ಬೆಂಗಳೂರು ನಮ್ಮ ಕೊಡುಗೆ ಮಾದರಿಯಲ್ಲಿ ಕರಾರಿನಂತೆ ನಿರ್ವಹಣೆ ಮಾಡತಕ್ಕದ್ದು ಹಾಗೂ ಸದರಿ ಕಟ್ಟಡದ ಕರಾರಿನ ಅವಧಿ ಮುಗಿದ ಮೇಲೆ ಸುಸ್ಥಿತಿಯಲ್ಲಿ ಪಾಲಿಕೆಗೆ ಹಸ್ತಾಂತರಿಸಲಾಗುತ್ತದೆ. ಅಕಾರ್ಡಿಂಗ್ಲಿ ಐ ಸ್ಟಾರ್ಟೆಡ್ ಕ್ಯಾರಿಂಗ್ ದಿ ವರ್ಕ್ my lord, I invested the amount. Now all of a sudden my lord, the local corporator who wanted to favor this thing to his own follower, annexure D, my lord, may kindly see for a moment to page 29. He writes a letter to the commissioner. Commissioner writes on the letter itself, get it cancelled immediately. ಸಿಲ್ವರ್ ಜುಬ್ಲಿ ಪಾರ್ಕ್ ನಲ್ಲಿ ಅನಧಿಕೃತವಾಗಿ ಉದ್ಯಾನ ಜಾಗವನ್ನು ನಿರ್ಮಿಸಿರುವ ಬಗ್ಗೆ, ಜಾಗವನ್ನು ಅತಿಕ್ರಮಿಸುತ್ತಿರುವ ಬಗ್ಗೆ, ಅಲ್ಲಿ ಏನ್ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇದೆ ಅದನ್ನ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅದನ್ನ ನಾವು ಮಾಡಿದೀವಿ ಅಷ್ಟೇ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಅಲ್ಟಿಮೇಟ್ಲಿ ಇಟ್ ಗೋಸ್ ಟು ದಿ ಕಾರ್ಪೊರೇಷನ್ ಓನ್ಲಿ. ಐ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಇಟ್ ಟು ಮೈ ಹೋಮ್. ಬಿಲ್ಡಿಂಗ್ ಏನಿದೆ ಅದು ಅವ್ರದ್ದೇನೆ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೈ ಲಾರ್ಡ್ ಗಾಟ್ ಇಟ್ ಪೇಜ್ 29 annexure D. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ನನ್ನ ವಾರ್ಡಿನ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಇತಿಹಾಸ ಪ್ರಸಿದ್ಧ ಸಿಲ್ವರ್ ಜುಬ್ಲಿ ಪಾರ್ಕ್ ನಲ್ಲಿ 3 ಕೋಟಿ ರುಗಳ ಅನುದಾನದಲ್ಲಿ ಅಭಿವೃದ್ಧಿ ಪಡಿಸುತ್ತಿರುವುದು ಸರಿಯಷ್ಟೇ. ಈ ಉದ್ಯಾನದಲ್ಲಿ ಸಾರ್ವಜನಿಕರ ಅನುಕೂಲಕ್ಕಾಗಿ ಈ ಹಿಂದೆ ಪಾಲಿಕೆಯು ಶೌಚಾಲಯವನ್ನು ನಿರ್ಮಿಸಿ ನಿರ್ವಹಣೆ ನಡೆಸುತ್ತಿದ್ದು, ಈಗ ಸುಸ್ಥಿತಿಯಲ್ಲಿರುವ ಆ ಶೌಚಾಲಯವನ್ನು ಪಾಲಿಕೆ ಅಧಿಕಾರಿಗಳು ಶಾಸಕರ ಹಾಗೂ ನನ್ನ ಗಮನಕ್ಕೆ ತರದೆ ಖಾಸಗಿ ವ್ಯಕ್ತಿಗೆ PPP ಮಾಡೆಲ್ ನಲ್ಲಿ ಮರು ನಿರ್ಮಾಣ ಮಾಡಲು ನೀಡಿರುತ್ತಾರೆ. ಆಸ್ ಇಫ್ ದರ್ ಇಸ್ ನೋ ಅಥಾರಿಟಿ ಅಂಡರ್ ದಿ ಲಾ ಅನ್ನೋ ತರ ಈ ರೈಟ್ಸ್ ಲೆಟರ್ ಬೀಯಿಂಗ್ ಎ ಕಾರ್ಪೊರೇಟರ್. ಖಾಸಗಿ ವ್ಯಕ್ತಿಯು ಶೌಚಾಲಯವನ್ನು ನಿರ್ವಹಣೆ ಮಾಡದೆ ಅಕ್ಕಪಕ್ಕದಲ್ಲಿರುವ ಸುಮಾರು 1000 ಚದರ ಅಡಿಗಳಷ್ಟು ಉದ್ಯಾನದ ಜಾಗವನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಶೌಚಾಲಯ ನಿರ್ಮಾಣ ಮಾಡಲು ಯತ್ನಿಸುತ್ತಿದ್ದಾರೆ. ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಪ್ರಕಾರ ಉದ್ಯಾನವನದ ಖಾಸಗಿ ಜಾಗವನ್ನು ಖಾಸಗಿ ವ್ಯಕ್ತಿಗಳಿಗೆ ನೀಡುವುದಾಗಲಿ ಬೇರೆ ಯಾವುದೇ ಉದ್ದೇಶಗಳಿಗೆ ಬಳಸುವುದಾಗಲಿ ಕಾನೂನಿನ ಪ್ರಕಾರ ಅಪರಾಧವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ದಯವಿಟ್ಟು ಈ ಕೂಡಲೇ ಈ ಅನಧಿಕೃತ ಶೌಚಾಲಯದ PPP ಮಾಡೆಲ್ ಕರಾರನ್ನು ರದ್ದುಪಡಿಸಬೇಕೆಂದು ಹಾಗೂ ಅಕ್ರಮ ಎಸಗಿದ ಪಾಲಿಕೆ ಅಧಿಕಾರಿಗಳ ವಿರುದ್ಧ ಸೂಕ್ತ ಕಾನೂನಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕೆಂದು ಈ ಮೂಲಕ ಕೇಳಿಕೊಳ್ಳುತ್ತೇನೆ. ಆನ್ ದಿಸ್ ಲೆಟರ್ ಆಫ್ ದಿ ಕಾರ್ಪೊರೇಟರ್, Commissioner Chief Engineer writes a letter, writes an endorsement. My lord, kindly see my note. What I have challenged in this fellow. CE South, immediately get it cancelled. Without looking to the background under which the MOU is entered into, work order has been entered into, is put to the petitioner. Of allowing me to invest the amount for renovation and other things. Scheme alle ಮಕ್ಕಳಿಗೆ
ಬೇರೆ ಏನು ಕಮಿಷನರ್ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಹೆಂಗಪ್ಪ?
ಇಡೀ ಅವರಿಂದ ಕ್ಲೀನ್ ಇರಲಿಲ್ಲ, ಅದು ಟಾಯ್ಲೆಟ್ ಕ್ಲೀನ್ ಇರಲಿಲ್ಲ ಅಂತದ್ರಲ್ಲಿ ಇದೊಂದು ಕೊಕ್ಕೆ ಹಾಕಿ ನಿಲ್ಸಿ ಮಾಡಿದ್ದೆ ಮಾಡಿ.
Executed MOU and Chief Commissioner writes like this.
Actually, I'm not touching it. Prayer person is not touching it. Page 131. Not to interfere with the work order.
ಹೌದು, ಅದು ಇಂಜೆಕ್ಷನ್ ಅಲ್ಲ, ಅದು ನಾಟ್ ಟು ಇಂಟರ್ಫಿಯರ್ ವಿತ್ ವರ್ಕ್ ಆರ್ಡರ್ ಅಂದ್ರೆ
they have already taken such an order before the civil court.
4/1/2000.
only legal service.
You're driving them to litigation, litigation cost you have to pay now.
384 malad that were rated.
70,000, 70,000 invest ಮಾಡಿ
Phone number 3 and 4
ಮಕ್ಕಳು.
against 3 and 4 malad were rated that illegal.
This is the scheme only, you are actually perpetuating injustice. That category people you are selecting and keeping them there only. That itself is injustice. Allunu matte idu problem.
Depending on the order malad road. Appear to be in
See them, my lord, they will be in such a pathetic situation, my lord, when you think morning, evening, ಅವರು ತುಂಬಾ ನೋಡಿದಾಗ
to see on the WhatsApp.
Voluntarily, you should come before the court and say, allow it anta. Ivella instructions hang ಬರಬೇಕು. They are undefendable.
ಅವರು ಬೇಕಾದ ವ್ಯಕ್ತಿ ಕೊಡ್ಬೇಕಂತ ಕಾರ್ಪೊರೇಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಷ್ಟೇ ಹೊತ್ತು ಇನ್ನೇನು.
Petitioner is before this court seeking for the following reasons. The petitioner is the son of a Paura Karmika who was
ವರ್ಕ್ ಆರ್ಡರ್, my lord, as per
work order on 4/1/2019. The build, operate and transfer on build, operate, transfer basis under the Namma Bengaluru, Namma Kodugi scheme to construct and maintain a pay and use public toilet at SJ Park Road, Tempo Stand, Ward number 119. The memorandum of understanding also came to be executed on 14/12/2018. What is the memorandum?
stated, my lord,
14/12/18 had already been executed on
14/12/2018.
in that regard. And the work order came to be issued after the petitioner had put up the construction of the toilet. The memorandum of understanding came to be executed on 14/12/2018 between the respondent corporation and the petitioner for renovation and maintenance of pay and use toilet. Build on transfer basis. Build operate transfer basis under the Namma Bengaluru Namma Kodugi scheme
For 10 years, my lord,
for a period of 10 years. In pursuance thereof, a work order came to be issued on 4/1/2019 permitting the operations of the said toilet. The petitioner
issued for 5 years, your lord, subject to renewal.
petitioner having rendered services, there being no complaint as regards said services, on a complaint filed by respondent number 3, the former operator, with the chief commissioner, contending that the BBMP ought not to allot toilets on a PPP model
This letter, Chandra also this letter.
He was the ಅದು ಜೆರಾಕ್ಸ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಬಂದಿಲ್ಲ ಪ್ಲೀಸ್.
fourth respondent corporate.
ಮಾತ್ರ ಕಳಿಸ್ತಾರೆ.
ಇಬ್ರು ಕೊಡ್ತಾರೆ.
Setting over farmer.
ಡಿ ಫ್ಯಾಕ್ಟೋ ಟೈಟಲ್ ಹಂಗೇನೆ ಇಲ್ಲೂ ಹಂಗೇನೆ.
ಸರಿ
ರಿಸರ್ವೇಶನ್ ಮಾಡಿಲ್ಲ ಇಲ್ಲ ಅಲ್ಲಿ ಯಾರೋ ಹಾಕ್ತಾರೆ.
You can't say anything. You can say a lot of things. We can't say that.
Why I am saying you are saying you see people are suffering with this reservation and other things. So not very difficult in the village also.
The PPP model should not be used for construction of toilets. And a further allegation being made that the petitioner had illegally put up a toilet at SJP Park, had called upon the petitioner to take action against the petitioner. The Chief Commissioner had on the said letter itself directed the Chief Engineer South to immediately get the work or immediately get it cancelled, thereby meaning to cancel the MOU and the work order issued to the petitioner. It is agreed by the same that the petitioner is before this court. Yes, Shivramu Learned Counsel for the petitioner submits that the petitioner belonging to a depressed class, having invested his own monies to put up the construction of a toilet and thereafter having renovated it, the fruits of the same are not being permitted to be enjoyed. Inasmuch as on a complaint filed by a local corporator, the Chief Commissioner has directed the cancellation of the MOU and the work order issued to the petitioner, which is unknown to law and is not in compliance with any known principles of law. And as such, he submits that the reliefs are required to be granted and the petitioner be permitted to continue the usage of the toilet for a period of 10 years as indicated in the work order. Very consider. What are your instructions?
Order it is 5 years is there, you will
It will not cause you a problem. What do you want to say? Say that. Do you say what we have to say? You whatever you want to say, we'll record.
ಪುನಃ ಅವ್ರ ಮರ್ಸಿಗೆ ಹೋದ್ರೆ ಇನ್ನ 5 ವರ್ಷ ನಮ್ಗೆ renewal ಮಾಡ್ತಾರೆ.
We won't say attribute anything to you. Having considered the documents on record, there being a clear memorandum of understanding executed by the corporation in favor of the petitioner and a work order issued to the petitioner to run the premises, to construct the toilet and run the premises for a period of 10 years and collect the amounts on the basis on pay-per-use basis. It is rather shocking that the commissioner, Chief Commissioner, has on a complaint made by the local corporator, directed the cancellation of the MOU stroke work order without even a notice. Has directed the Chief Engineer South to cancel the MOU stroke work order.
ಚೆಕ್ ಮಾಡು ಅಂತ ಬರ್ತಾರೆ, ಅವರು ಕ್ಯಾನ್ಸಲ್ ಅಂತಾನೆ ಬರ್ಬಿಟ್ಟು ಜಾಯಿಂಟ್ ಕಮಿಷನರ್ ಚೆಕ್ ಮಾಡಿ ಅಂತ ಬರ್ತಾರೆ, ಇವರು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಾಕಿದ್ರು.
Joint Commissioner check.
27 ತಾವು ನೋಡಿದ್ರೆ ಜಾಯಿಂಟ್ ಕಮಿಷನರ್ JC South, please check the
license. There is no notice which had been issued to the petitioner. There is no allegation against the petitioner as regards any shortcoming in the services rendered by the petitioner. Such being the case, it was not permissible for the Chief Commissioner of the BBMP to have made a laconic endorsement on the complaint submitted by respondent number 4 to get directing the Chief Engineer South to immediately get it cancelled. Such an action is not expected of the Chief Commissioner, who has to lead by example and follow the applicable rules. Since not having been done, I pass the following order. Writ petition is allowed. Sir, I issued the endorsement made by the Chief Commissioner on the letter dated 19/3/2018 issued by the fourth respondent, Objection D. He is hereby quashed. Respondents, the mandamus is issued directing the respondents to permit the petitioner to discharge his obligations under the work order dated 4/1/2019 without any interference until the period of 10 years elapsed from that date. Thanks. Thank ಇದೆಯೋ ಹೇಳಿ ಮಿಸ್ಟರ್ ಟ್ಯಾಂಕ್ ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಅಬ್ಸರ್ವ್ ವಿಲ್ ರೆಕಾರ್ಡ್ ಇಟ್ ಅಂಡ್ ಡೈರೆಕ್ಟ್ ದ ರಿಮೂವಲ್ ಆಫ್ ದ ಟ್ಯಾಂಕ್. ಇದೆ ಅಂದ್ರೆ ದುಡ್ಡು ಕೊಡಿ. ಯು ಕ್ಯಾನ್ ಬಿ ಸಿಟ್ಟಿಂಗ್ ಆನ್ ದ ಫೆನ್ಸ್ ಫಾರ್ ಲಾಸ್ಟ್ 2 months ಆನ್ ದಿಸ್. ಸೋಮವಾರ ಮಂಗಳವಾರ ಅಷ್ಟೇ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಕೊಡ್ಬೇಕಾ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್? ಯಾರು ಕೊಡ್ಬೇಕು? ಅವ್ರನ್ನೇ ಕರೆಯೋಣ. ಅವ್ರು ಬೇಡ, ಇನ್ಯಾರು ಇದ್ದಾರೆ ಹೇಳಿ. 4 ಇಲ್ಲ ಅಂದ್ರೆ 3 ಕರೆಯೋಣ. Let him appear through VC. Private property you can't take and do this. At the request of Shri BJ Somanji, read this on 19th, on 20th. By the time submissions are not made, respondent number 4 shall be personally present before this court at 2:30 p.m. 20th at 2:30 p.m. It was last day, but
The fact shown in the petition. The fact as per the sanction plan is, the petitioner is shown is different than the respondent. But with regard to that, you have also directed to.
ಸೇಮ್ ಇರ್ಬೇಕಾಯ್ತಲ್ಲ, ಸೆಟ್ ಬ್ಯಾಕ್ ಒಬ್ಬೊಬ್ಬರಿಗೆ ಒಂದೊಂದು ಯಾಕೆ? Why discriminatory setbacks for neighbors? What is
that? The fact of concern, I have construction without the land, I can order to get this department confirming.
ಈಗ ಯಾರಿಗಿದ್ರಲ್ಲಿ? Private restaurant, not for the authority. Appears for this one.
I not have sanction. Measurement on the rare side.
ಇವಾಗ ಒಂದು ಅಪ್ಲೈ ಮಾಡಿ.
Only to that extent.
Because of my privacy is strengthened by the respondent number 3. Directly made the construction. My privacy, that we put the windows and main doors to access my private, that is bedrooms as well as the bathroom.
Access your private. ಅದೆಲ್ಲ ಸುಮ್ಮನೆ ಅಷ್ಟೆಲ್ಲ ಹೇಳಕ್ ಹೋಗಿ.
Tell us, it has been constructed like that. Deliberately, he
ಅಲ್ಲಿ ನಾನು window ಇಟ್ಟಿದ್ದೀನಿ ಅಂತ
ನಿಂಗೆ
why does not
ಎಷ್ಟು ಸೈಟ್ ಮೆಜರ್ಮೆಂಟ್ ಏನಿದು?
measurement followed the measurement of petitioner and respondent side of measurement for 100.
What is the ones we have to get to know from? What is the setback? Actual setback, you have to produce that. What are the rules applicable for setback? And counsel for respond number 1 and 2. Once again seeks for the short accommodation. He directed to comply with the observations made in para 2 of the order dated 8/11/2023, as also to produce the relevant setback rules applicable to the properties in question. Relist on 8th January.
Amendment application. Yeah. Need to file a statement of objection. Also, they need to file the amended petition.
When petition filed? That counsel for the petitioner seeks for and is granted 2 weeks time to file the amended petition. Counsel for respondent number 1, 2, 3 seeks for and is granted 3 weeks time thereafter to file his statement of objections. Objections, if any, to be filed on or before 30th February, released on 5th February. 30th January, released on 5th February. Kalyan. Attend to answer. Just on 2nd February.
Before some request, there was an injunction order granted in my favor. And subsequent, that was heard before the trial court. And not status quo order has been passed by the trial court. Not saying that they should take to the extent that it has been sanctioned. After the payment of objection.
New wood logs using high volt machines and B-scale property, pending disposal.
Subsequently, order number 1 is restrained from cutting up any of the logs under the. But because I have purchased the property for the extent of 5 cents. Retained it 10 cents. In that 5 cents, they wanted to.
Silly idea. Will cut in his property.
Thereafter, approach to the executive and filing an appeal. And thereafter,
Is suitably the order as well, that also, that is what will endure to happen. So this petition will be disposed of.
That's all. 44 kindly be seen.
Petition we are disposing of in terms of the order as I civil court ಅಲ್ಲಿ pending ಇದೆ ಅಲ್ಲ. Petitioner is before this court seeking for the following reliefs. The petitioner had also filed a suit in OS number 276 of 2018. The principal civil judge and judicial magistrate first class at Kundapura, while ordered dated 7th August 2023, has restrained the defendant number 1 therein, who is only defendant number 1 therein, who is respondent number 1 herein, from cutting any wood logs using high volt machinery in B scheduled property, pending disposal of the said suit. The said order addresses the grievance of the petitioner in the present matter. Hence, the petition stands disposed. The rights of the parties to be determined by the trial court in OS number so much.
Violation is there. Filing the appeal for the executive. For the reason that.
Now this is seized of it. ನೀವು 39(4) ಹಾಕಿದಿರಾ, contest ಆಗಿದೆ, order ಆಗಿದೆ, modify ಆಗಿದೆ, ಅಲ್ಲಿ it will decide. You have disposed of the writ petition.
Any observations are there? Any violation?
We decided in the trial court and ಹೇಳಿದ್ರು. So no other thing will come here.
Is not there, I'm a party to this case.
Your senior, eh?
My senior is not there. I'm a party to this case. I'm on the petition. My father passed away this year. So,
So you want adjournment?
yeah.
We have the counsel for the petitioner, a short accommodation is sought for. We list on 5th February. Reconciliation ಆಯ್ತಾ? Despite the the petitioner is before this court seeking for the following leaves. Despite order dated 12/10/23 and 29/11/23. Neither is the reconciliation of accounts taken place nor the amounts deposited. There being non-compliance with the orders of this court, the petitioner cannot, the petition stands dismissed for non-prosecution. Liberty is our reserved to the respondent to recover such money as they claim from the petitioner by instituting appropriate proceedings. Petitions ಹಾಕಿದ್ದೀರಾ? The counsel for respondent number 2 and 4 submit that she does not wish to file any additional statement of objections. Relist on 5th February. Interim order earlier granted is extended till next. Relist on 15th February. Appears relist on 16th February. So none appears for the petitioner. Relist on 16th February. None appears for the petitioner 16th February. Respondent. None appears for the petitioner. Relist on 16th February. When will you file, madam? Counsel for whether the CGP 6 fund is granted 4 weeks time to file a statement of objection. Objections pending by 31st. Relist on 9th February.
Clarification regarding the driveway.
Clarification regarding
Application needed.
dues of 20.
Not from, we have given representations to the rear. Ask for one.
ಅದು ಬಂದ್ಮೇಲೆ Panindra had appeared.
Yes.
That counsel for the petitioner submit that an application has been made to the Real Estate Regulatory Authority seeking for a clarification. He seeks for and is granted 4 weeks time to seeks for and granted 4 weeks time to place the same on record. If the clarification is received earlier, petitioner is at liberty to move the matter. Relist on 5th February. Late agata parlinda yadu. Who appears for the
15th is last time. 15th is point.
subject property.
After 15 interim order, ಅಲ್ಲಿ ಮೂರ್ತಿ ಎಲ್ಲ ಇಟ್ಟು
Temple was existent from past more than 80 years, my lord.
ಅವ್ರದ್ದು ಟ್ರಸ್ಟ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ 23 ಟ್ರಸ್ಟ್ ಇದೆ.
We have directed you not to carry out any construction.
No construction has been carried out, my lord. The temple has already been constructed earlier, much earlier, and every year the festival is going on. But
File your objections, Mr. Sumit.
it is only for the devotees of the.
Annexure A Sudi, that trust deed itself is 1/7/2023. ಅವರು ಉಳಿದವರೆಲ್ಲ ವೇಕೆಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ಕೊಂಡು ಹೋದ್ರು. ಈಗ ಅವರು ಇದು ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರ ಹೆಸರಲ್ಲಿ ಆಗ್ಬಿಟ್ಟು ಈಗ
All petition are there only.
ಇದು
Aadhaar card has been issued. Aadhaar card has been issued. They are deciding.
Not, this is for a house. This is not for a temple.
Right.
So there is no temple which can be constructed there.
Here the Mr. Ravichandran,
There is nowhere there and tenu illa. It's a residential property, you can't have a temple.
but
So we'll direct,
Ravichandran, ಅವರ ಜಾಗದಲ್ಲಿ ಅವರು ಕಟ್ಟಿಕೊಂಡಿದ್ದಾರೆ ತುಂಬಾ ವರ್ಷ.
Direct respond number 2 to remove it. Direct respond number 2 to remove it. The deputy commissioner will.
ಕಟ್ಟಿಕೊಂಡಿದ್ದಾರೆ ತುಂಬಾ ವರ್ಷದಿಂದ every year ಜಾತ್ರೆ
It's a
ನಡೀತದೆ.
residential property, ಜಾತ್ರೆ ಆಗ ಚಾನ್ಸೇ ಇಲ್ಲ.
ಅದು
Don't make all these statements.
ಅಲ್ಲ ಅವ್ರಿಗೋಸ್ಕರನೇ ಸ್ವಾಮಿ.
Don't make religion a business. This is a residential house.
He will file objection with that readings are not completed.
You stop the temple.
No interim order is granted. Interim order is
We directed you not to construct last time.
ಫಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡಿ ಆದ್ಮೇಲೆ
not to dispose.
ಎಲ್ಲ ಮೂರ್ತಿ ತಗೊಂಡು ಬನ್ನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡ್ಬಿಟ್ಟು ನವೆಂಬರ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. ಮೂರ್ತಿ ತಂದ್ಬಿಟ್ಟು ಇದು ಆಫ್ಟರ್ ದಿ ಎಂಟ್ರಿ ಮಾಡಿ
On 16/11.
ಎಂಟ್ರಿ ಮಾಡಿ ಆದ್ಮೇಲೆ
ಯಾಕಪ್ಪ ಹಿಂಗ್ ಮಾಡ್ತೀರಾ? Even that God won't forgive them.
ಮಾಡಿಲ್ಲ.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿ
ಇದು every year ಜಾತ್ರೆ ಮಾಡ್ತಾರೆ ಟೆಂಪಲ್ ಎಲ್ಲ. ಹಾಗೆ ಸ್ವಾಮಿ.
120 feet into 80 feet. ಅವ್ರ ಪ್ರಕಾರ
This is Ashraya scheme. If it's Ashraya scheme, then you can't have a benefit of it at all. As simple as that.
Temple is the existence only for those local.
Ashraya is not for God. Ashraya is for individuals. As simple as that. And you are misusing the Ashraya scheme to construct a temple.
Already.
And demolish ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ.
Existence long year.
See,
Every year.
Somaji Learned Counsel for respond number. Pamphlet
Only.
For respond number 5 to 7. Submit that respond number 15 is seeking to make use of a plot reserved for allotment to homeless persons under the Ashraya scheme for the purpose of construction of a temple. If that be so, it is for respond number 2, take necessary action forthwith, so that no such construction of temple or operation of a temple takes place in a plot coming under the Ashraya scheme.
any activity. So
The plot be used only for residential purposes. ಇವಾಗ ಒಂದು ಟೆಂಪಲ್ ಆಗ್ಬಿಟ್ಟು ಫುಲ್ ಎಲ್ಲ ತಗೊಂಡ್ಬಿಟ್ಟು ಪಾಪ ಎಷ್ಟು ಜನಕ್ಕೆ ಮನೆ ಹೋಗುತ್ತೆ ಗೊತ್ತಾ?
ಅವ್ರ ಜಾಗದಲ್ಲಿ ಮಾತ್ರ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಆ ಸೈಟ್ ನಲ್ಲಿ ಮಾತ್ರ.
A on-site report as regards the action taken to be filed by responding on the next date of hearing, released on 8th January.
In respect of
File your wakalat at it.
in respect of petitioner number 15, that is the only.
There is no temple in that area for residential plot error.
The residents are residing there.
It is only an house plot. House plot is ಮಾಡಿ. ನಾವು ಎಲ್ಲರಿಗೂ ಮನೆ ಕೊಡ್ಸೋಣ ಅಂದ್ರೆ ನೀವು
ಅಲ್ಲ, this hard.
ಇವ್ರು ಕೊಡ್ತಾ ಇಲ್ಲ ಮನೆ, ನೀವು ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಟೆಂಪಲ್ ಬೇರೆ ಮಾಡಿ. ನೀವು ಇದು ಮಾಡ್ತೀರಾ ಅಂತ ಅವ್ರು ಬೇರೆ ಅವ್ರು ಕೊಡಲ್ಲ.
This RA, that's mainly for RA. So my name may be taken on.
Have you filed your wakalatnama?
Only what the instruction.
Have you filed? Once you file, your name will come.
This is only that's right. Petition on 50.
The temple, wherever it is located.
Not only.
Interim order is extended till next day.
If you want to see, one to put.
1 to, interim order 1 to 14.
Okay, this is Prakash.
Counsel for respond number 2 and 3, confirming receipt of the copies of petition. 6 for and is granted 4 weeks time to file a statement of objection. Objections, if any, by 31st January, relist on 8th February. Yes.
The forward to WhatsApp.
License fee ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ನೀವು ವೆರಿಫೈ ಮಾಡ್ಬೇಕಾಗಿತ್ತಲ್ಲ ನಿಮ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಇಲ್ವಾ ಅವ್ರ ಲೈಸೆನ್ಸ್ ಫೀ ಕೊಟ್ಟಿರೋದು ಇದ್ದೇ ಇರತ್ತೆ ಇಲ್ಲಿ ನೋಡಿ ರೆಸೀಟ್ ಇದೆ. And counsel for the petitioner has today furnished a copy of the receipt for having paid the license fee to the counsel for respondent number 4, 6, 7, 8 and 9, who seeks bond is granted 2 weeks time to verify and make his submission as to whether the license fee has been received or not. Released on 32nd January. They will take their own time to get it. Wait for some time. Yes. Just on relation number 4. Why is deferred? Yes. So we'll say 9 meters, another officer will say 12 meters. So that will have to be given by. Yeah. You will have to, who are you appearing for, Mr.? So you have to make it clear. They have written to you.
It's very clearly. Stipulates the maintenance of a 9-meter buffer. However,
ಅದಕ್ಕೆ ಗೈಡ್ಲೈನ್ಸ್ ಕೇಳಿ.
applicable guidelines on repeated requests is not being communicated.
Whose guidelines are your guidelines or their guidelines?
It's not for that thing.
What law, Mr. Zuraikar? Anybody can say anything unless you have something. ನಾಳೆ ಆಫೀಸ್ ಚೇಂಜ್ ಆಗ್ಬಿಟ್ರೆ ಬೇಡ ಅಂತಾರೆ, ಇನ್ನೊಬ್ರು ಬಂದ್ಬಿಟ್ಟು ಬೇಕು ಅಂತಾರೆ. So it's not there. Then this claim is wrong. Come on, sir.
They have filed a writ appeal. I filed one to and for submission only. I filed a writ appeal. On the ground that there was some wedding that was scheduled. The court gave me limited protection until those weddings have been concluded. We are no longer using the property for any commercial purpose.
Yes, so you are,
You know,
if you had told us only, we would have given you
no,
that.
last occasion, the party was in Rajasthan, I didn't know instructions, but in time the order came, we realized. I know like my only submission, my lord, is that with respect to what the protection I had till 11, the weddings have been concluded. Now I'm not putting the property to any commercial. Maybe wanted to take like suitable action against any such commercial act.
Commercial activities you can take, but you can't ask for this demolition, etc., when there's no such buffer.
Then for the clarification in the
Even get. Who you wrote to is next to you, so he may back again. Petitioner is before this court seeking for the following reliefs. Petitioner claims to be a public charitable trust registered under the Trust Act, but a trust deed dated 1998. And it purchased 19 guntas in survey number 173/13 in Tumkur village, Kasba Hubli, Tumkur Taluk, 8/10/2002. As also the adjoining property on 10/1/2002. The petitioner applied for a single plot approval and put up and after receipt thereof has put up a construction thereon. On 31/7/22, when respondent number 2 came with a JCB and destroyed a portion of the petitioner's boundary wall, the petitioner addressed complaints to respondent number 2 and the superintendent of police and associate deputy commissioner, claiming that the said action is high-handed. Thereafter, respondent number 3 issued a notice on the basis of an alleged complaint by a third party that the petitioner had encroached upon a Rajikal way. The petitioner, though there is a spot inspection conducted, the petitioner was not informed of the same. And the demolition of the petitioner's boundary wall was carried out without any notice to the petitioner. Petitioner having complained to respondent number 2, the deputy commissioner and superintendent of police, no action was taken. He said the jurisdiction police had issued an endorsement stating that it was for the respondent number 2, the commissioner Tumkur City Corporation, to take a decision on. On 3/11/2023, a notice came to be issued by respondent number 3, stating that there was a Kodi Halla in the property. Next to the, and therefore respondent number 3 had carried out marking of the property of the petitioner for demolition. It is challenging the same that the petitioner is before this court, seeking for the aforesaid relief. Shruti C. Chaganti, learned counsel for the petitioner, would submit that there is no prescription of any buffer zone. You admit Kodialla, you don't admit Kodialla. Not in this. there is no buffer zone prescribed for a Kodiala in any of the zonal regulation or under any law. The plan, I mean, sanctioned by respondent number 2. And a single plot license having been issued by respondent number 4. All these aspects are deemed to have been looked into by the concerned authorities. The construction having been put up, the action against the petitioner is being taken on the basis of a complaint by a competitor of the petitioner who is in the vicinity of the, who carries on the business in the vicinity of the petitioner. At this stage, Ms. Sakshi M. Krishna, learned counsel appearing for respondent number 2 and 3, submits that the plan sanction which has been issued had submitted that the plan sanction which had been issued to the petitioner was only for residential purpose, and therefore no commercial activity could be taken on, could be conducted in the said property. As such, this court had, while order dated 29/11/23, restrained the petitioner from carrying on any commercial activity in the premises, but to use the premises for residential purposes. Today, after today's submission is made by Shri T.P. Vivekanand, learned counsel for respondent number 4, on instructions that there is no buffer zone which is prescribed for the Kodiala in the zonal regulations. And it's only by way of abundant caution that a request is made. For maintaining a 9-meter buffer zone. Blaming each other. I have the considered opinion that if the law does not, or the Urban Development Authority cannot unilaterally fix a buffer zone and direct a private citizen to maintain such a buffer zone, the concept of buffer zone and the extent of buffer zone would have to be one recognized under law and imposed on everyone uniformly. In the present case, only on the basis of a opinion of an officer, a 9-meter wide buffer zone cannot be so fixed. If at all the corporation and or the Urban Development Authority intends to fix any buffer zone, the same would have to be fixed after following due procedure in accordance with law. Insofar as the petitioner is concerned, the petitioner having constructed a commercial building has been restrained from using a building which was used for commercial purposes.
It's Margari, they go to Margari, so built it. How many submissions have been permitted?
Good.
It's not a commercial building, it's not a submission.
Been constructed a building which was used for construction and commercial purposes, had been restrained from using it for commercial purposes. The said order of restraint would continue. The petitioner would be entitled to make use of the property for residential purposes until and unless the petitioner were to follow the applicable law and obtain such permission from the appropriate authority for use of the premises as a commercial premise. In that view of the matter, I pass the following order. Yes.
I tried to apply to change land use, but the authorities actually told my class that only if the High Court permits the application.
The court will not say anything.
So my
in accordance with it. It is an online application, nobody can refuse it.
Such an application is made, we will consider it.
In that view of the matter, I pass the following order. Certiorari is issued, the notice dated 3/11/23 bearing number so and so issued by respondent number 3 at annexure F is quashed. Certiorari is issued, the notice bearing number so and so dated 17/8/22 at annexure D is quashed. The petitioner is permitted to make use of the property in question for residential purpose and is restrained from using the property for commercial purposes unless an application is made and duly approved by the concerned authority for change of land use.
Allocation, considering the
order not come in the way of the authorities taking any other action in terms of any.
What other action you want? What other action? That you will always have. You get an order from the court to misuse. Court has said, therefore we have issued bad action.